Grace and peace, everybody. Good to see you and a happy Tuesday morning to you all. Woo, we got a lot to talk about today. So, yesterday we kind of started out discussing or ended discussing the whole shenanigans that was in Monday's YSL Young Thug trial. And it was rich. It was fraught with shenanigans and so forth. So what I wanted to do today is really address the topic that most people have on the back of their mind. So you saw the thumbnail and you saw the title, so you know what we're about to do. We're going to talk about whether or not we believe this is going to go to a mistrial. Now, at the end of the day, we're just bystanders, and I'm not a legal expert, and neither are you, unless you are, of course. And if you are, holla at your boy. I need some help. But let me turn off this video has popped up in my ear. All right, so what we want to do is just kind of, if for lack of a better term, dissect this discussion from just the average Joe and the average Jane's perspective. Now, there's going to be actually parts of this complaint and motion that ask, would the normal average person believe that the judge was operating correctly, and so forth. And even in Ashley Merchant's complaint against Fonnie Willis, is it normal for you not to produce FOIA information when requested? Because you actually have 3 days to do it, and Fonnie Willis doesn't do it. So today, that's all we're going to talk about. I'm going to read through these two complaints, hear your feedback, get your concerns, your understanding of it, and then we're going to call it a game. So I thank everybody that's already in the chat. Looks like there's lots of good family reunion already going in the chat. You know, I love when I see that. So I really do appreciate everybody that's already stopped through, giving a shout out and so forth. So let's just see what we got. I got my good friends. All right. Robin, good to see. Well, let me do it like this. Sorry about that. Because you need to be able to see it, don't you? It's too early in the morning, y'all. It's too early. And I get up early, and I'm talking about it's too early. All right, let's get it going. Let's go on. Robin's in the building. Good to see you. He says, all right, let's go, go, go. MMCS. Always good to see retired in the building. Thank you so very much. My good and favorite transplanted Texan is here. Good morning, DWC Live Chat. The best on this planet and the dwarf planet, Pluto. Salute. Absolutely. This is, if you're watching and hanging out with us and you don't know what this is about, my name is Jason. I'm a content creator here in Atlanta, Georgia. I like to give social and political commentary from a Christian male perspective. And I'm heartbroken to see so many people focusing on my favorite city with disdain and mockery. And we're the laughing stock of, dare I say, the whole world at this point. So I'm hoping and praying that good things will come, and that, of course, Atlanta will be seen for what she is as a wonderful, fantastic place to live and to grow, to raise a family and so forth, do business. But at the current moment, it's a laughing stock. So I do this because I want to kind of delve into it, hear other people's perspective and opinions on this topic. So I appreciate all 20 of you all that are watching. When you come on in, make sure you say hi. Holla at your people. You are part of the best live chat on the planet. So just make sure you give them a little hi and say what's up. There's a little button at the top. It looks like a thumb. You click on that button and you get instant privileges of being a member of the best live chat on the planet. And what are those privileges? We haven't worked those out yet, but I appreciate you. If you do like this content, hit the like button. If you don't like it, hit the like button 3 times. It sort of kind of does the same thing. Anyway, let's keep this going. Who else we got in the building? My good friend Q is in the house. Always good to see her. She's probably in a meeting, probably ear hustling. One ear on the meeting, the other ear checking out what we're talking about over here. So good to see you, Q. Always good. Sarah's in the house, as well as Rechurch. Thank you so much for stopping by, all of you all. Now, we are blessed. We are blessed and highly favored. You know why we're blessed and highly favored? Because Shar Joel's in the building. Good to see you, Shar. Always good to see you, friend. Good to see you for sure. Y'all make sure we say shout out to Terry, because Terry's here. And I usually do this just because I appreciate the live chat. Me sitting here in my office or in my studio talking is fun, sure. But if you all weren't here, I would just be talking to myself, which is what my kids say I do anyway. So we got Connie in the building. Good to see you. Thank you so much. Let's get this party rolling, everybody. Let us get ready to go. So Just lay of the land. Yesterday was a scheduled dumpster fire, and it was exactly that. It did not disappoint in the YSL case. However, at a shocking turn of events, right at the end, right as everybody was leaving, Brian Steele, I call him Brian Steele, the gangster Brian Steele, takes a Molotov cocktail and chucks it into the courtroom. And what was that Molotov cocktail, you might ask? Well, here it is. Brian Steele dropped last night at 4:59 p.m. So that's, literally people getting in their car trying to go home, get ready to order food and whatnot and pick up for the family. He throws this thing into Judge Glanville's lap. And it says the following: in the Superior Court of Fulton County, state of Georgia, Georgia versus Jeffrey Williams. And what is this thing, Jason? What is it? It is the motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case, and motion for mistrial, which was goaded. And I need to look up the word goaded. One of the moderators, please tell me what goaded means. I think they're trying to say like prodded and precipitated by, but that's what I want to make sure of goaded. Because I know that Brian Steele is the GOAT, but I want to make sure that goaded, I'm using it correctly, goaded by the improper conduct committed in concert by the court and prosecution. That sentence right there is a banger. And there's going to be a lot more of them in here. But Brian literally just threw this right on Judge Glanville's lap. Said, oh, yeah, I got something for you. Yeah, that whole contempt thing, let me skyhook this into your lap. Good gracious. Comes now Jeffrey Williams, a.k.a. Young Thug. I'm going to call him Young Thug because I like saying Young Thug. All right, Young Thug, by and through undesigned counsel, and hereby files the motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case. We kind of already read this before, Jason. Conduct committed in the concert. Yeah, we already said this. In support of the motion, Mr. Williams shows as follows. Let's go. Undersigned counsel represents Mr. Jeffrey Williams, also known as Young Thug. In the above referenced case, the jury trial of multiple accused persons commenced on January 4th, 2023. So that's literally a year and 5 months ago. That's when it started. Before Fulton County Superior Court Judge Glanville, the trial is expected to last at least through the end of 2024 calendar year. I'm sorry. That is hope upon hope. I have no idea how they believe that's going to happen. But hey, hats off to your dedication. I ain't mad at you, but my goodness in the morning. On Monday, June 10th, 2024, within 5 days of the filing of the timely motion, this court, along with the prosecution, engaged in an unlawful, improper ex parte, we'll call it the secret meeting. I like saying ex parte too, though. I'll go with either one. Ex parte meeting with, among other persons, a sworn witness, Little Woody, for whom the order of use immunity had been issued on Friday, June 7th, 2024. No notice of this secret meeting was provided to any attorney for any of the criminally accused in the case. In fact, the accused and their counsel were in the dark. All right, man. He's laying out this case, and he's going to go through the whole thing, all of the shenanigans that happened, all of the hijinks, all of that stuff. So let's let Brian Steele cook. This chambers meeting occurred. Little Woody had previously been called to testify on Friday, June 7th, asserting the Fifth Amendment privilege in open court in front of the jury, and was held in contempt and summarily incarcerated until such time as he agreed to testify pursuant to the grant of use immunity. Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that an ex parte meeting occurred on the morning of June 10th. And I think that's interesting. Let me stop for a second. He's saying they had the secret meeting, and then they kind of referenced the secret meeting in court before all the stuff hit the fan. So he's like, they kind of mentioned it. And I didn't go back to look, and maybe if I do, maybe we'll run across exactly what did they say that kind of gave off a hint or gave off the odor of a secret meeting. I don't know if there's an odor of mendacity in a secret meeting, but probably so. But I can see what he's saying there. So y'all was hanging out, and then y'all was referencing you're hanging out in front of everybody in the group when everybody in the group wasn't invited to hang out. I can see that. Let's keep this game going. Occurred in the morning of June 10th, only after undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. And again, you got to wonder, like, what in the world were you thinking that this would be the right thing to do? And it's not. Let's keep going. Section 3. At the earliest opportunity on the afternoon of June 10th, the court was informed, based upon the information and belief, that the secret meeting was with sworn witness Little Woody and the prosecution occurred earlier that day, that the witness had been had made factual admissions, and that statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Mr. Copeland would be held in custody on contempt. Remember, and he's going to talk about it in a moment, they said they're going to keep you in court not till the end of the Young Thug case, but till all of it is cleared up. And that could be in excess of 2, maybe even 3. I personally think they basically said, we're going to keep you in jail for 5 years for contempt. And this does go back to the whole thing with Fonnie Willis and what's going on in Fulton County Jail with so many people held in jail without being indicted. Are there people like this? Are there people like this that Glanville or other judges have just thrown in jail? Say, oh, you don't want to tell me? Then you can stay there until, whenever the cows come home. Is that what's going on? I don't know, but I'm just wondering. Let's keep it going. The court denied the undersigned counsel's request for the transcript of the secret meeting and denied the timely motion for mistrial based upon the improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, a fair trial, and a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. This guy's cooking. He is cooking. I mean, Brian is just bringing it, and it's only going to get gooder. So go ahead and pull up a plate, get your favorite beverage of choice, because we got a lot to do tonight. A lot to do today, not tonight. Uniform Superior Court Code. I'm not going to read that. Rules governing exact secret meeting communications. Uniform Superior Court Rule 4.1 generally prohibits secret meeting communications except as authorized by law or by rule. Judges shall neither initiate nor consider secret meetings communications by interested parties or their attorneys concerning a pending or impending proceeding. Silent meetings, or rather secret meetings, hearings, and only authorized as in the case of extraordinary matters such as temporary restraining orders or temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity to attend and voicing any objections that may be properly registered. And it gives a lot of legalese right there. City of Pendergrass and Skelton. Interesting. Okay. I think we all can understand, and he gives lots of precedent right here. I'm not going to bog that down because I do want to get, at the end, he leaves a narrative, and it is amazing. So I do want to get to that narrative. Let's jump to 6. The trial court rejected undersigned counsel's substantive request for the information about the unlawful ex parte meeting, and the court denied the undersigned counsel's motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of the information about the ex parte meeting. And I'm going to say something here. I know this sounds crazy, but when you hear Ashley Merchant explain to Judge Glanville about civil and criminal contempt, I got this bad feeling. This is going to be wild. I got this bad feeling Judge Glanville doesn't know what is legal and not legal in ex parte meetings, or when you should and shouldn't do it. That sounds crazy, but I don't think he does. And this is not the first time that he's been schooled by an attorney in his court. And it was really grievous when you watch Ashley Merchant, and I think the guy's last name was Sharp, man with the ponytail. They explained to him it was pretty bad because you can tell up front Glanville knew what he was talking about, only to be like, no, you're wrong. And they broke it down and said, this is what it is. It was bad. It was really bad. I hate to say it. I don't think he knows this. I don't think he fully understands what is right and wrong as relates to meeting with counsel outside of, without both sides. I know that sounds crazy. And I also believe he's probably done this before, whether it be in the Young Thug case or some other case before. This having a secret meeting without conversing with the other counsels, I can totally believe that he's done this before because he just seemed too natural about it. Like, oh no, you'll get the transcripts later. At the end of the show, we'll give you the transcripts. It just he seemed entirely too comfortable. I fear, one, he doesn't know that he's wrong. And two, he's done this multiple times before, probably in this case, but definitely in some other case that he sat on the bench for. I know that sounds crazy, but the way that when Ashley explained stuff to him and he was really, as I like to say, loud and wrong. You can be wrong, just don't be loud. You can be loud, but don't be wrong. But he was loud and wrong. And he knew he was right, only to find out he was wrong and loud. So I really don't think he knows. And I'm trying to give him the benefit of the doubt. And what I mean by that simply is that he's done this before. But let us keep going. The prosecutor stunningly sat mute and permitted this injustice to occur and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office, argued that the secret meeting hearing with witness Woody was ethical, just, and proper. The other prosecutor still remained mute. I like the way Brian writes. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on the state bar rule of professional conduct 1.6, which states in pertinent part that, let's jump on over to the next page. I've got to get this to scroll. I don't know why it won't scroll. And now it's gone. Well, that's not good. All right, I'm gonna make this screen a little bit different because it's not allowing me to scroll properly. I don't know why. I do want to make it larger so y'all can read it along with me though. We were on 6, right? We were done with 6, going into 7. So we're on page 5, okay. I do want to read this though because it was pretty good. Let us go. A lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate, or the disclosure of which would be an embarrassment or would likely be detrimental to the client unless the client gives informed consent, except for disclosures that are implied, authorized, or in order to carry out the representation or are required by these rules or other law or by order of the court. Let us go. Let us go. Okay. The principal confidentiality is given effect in 2 related bodies of law: the attorney-client privilege, which includes the work product doctrine. And Brian Steele used the work product doctrine basically to say that what he gleaned, we'll find out who it was that actually was the rat. I won't say the rat. The person that gave Brian Steele the inside scoop on the secret meeting. And he explains, like he said, that this is work product. which is basically, I guess you could say the best way that I could understand it is like if you were sitting in a meeting and you were writing notes down in order to go home later on and write out a paper about the meeting that you were in. Those notes would be considered like work product. Maybe your scribblings down, some dates, some times, different little factoids, so on and so forth. You consider those like work product. And it's just, they're not like official court documents, and they're not officially thought out, fully orbed out notes or commentary, but rather they're just your cliff notes, your shorthand, if you will. And that's what I believe Brian is saying with the work product doctrine, that basically when that person came to him and told him this information, it was work product. But let's keep going. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of the client-lawyer confidentiality applies in situations other than those where evidence is sought from a lawyer through compulsion of the law. Rule 1.6 applies not merely to matters communicated in the confidence by the client, but also to all information gained in the professional relationship, whatever its source. So I think that's what he was leaning on. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. Okay. Brian Steele's basically saying, I don't got to tell you this stuff because it's all a part of my work product dealing with my client. And because of that, I don't have to tell you where I got this stuff from. And I do think it was interesting, especially if you saw the big exchange, the big blow up in Judge Glanville's office. Well, the problem is Judge Glanville never admitted that the secret meeting didn't happen, which the secret meeting was wrong. That was wrong. And that's why I really believe he's done this before, in my opinion, because he just did not seem fazed by the fact that you were doing something wrong. Like, how dare you call me out for speeding? Sir, you were speeding. How dare you use a laser tracker to track my speed? How dare you do that? Sir, but you were speeding. How dare you? Who authorized you to use a laser tracker? I want the laser tracker. Sir, you were speeding. And he just seems to ignore the real glaring issues that he was doing wrong. Number 9. The court ignored the ethical rules relied upon and continued to demand undersigned counsel to reveal the source of information, claiming that the way that undersigned counsel obtained the information was somehow unlawful, and baselessly accused undersigned counsel on the record of potentially acquiring information through eavesdropping, ear hustling even. He blamed him for ear hustling, but he didn't admit that what he was doing was wrong. That's the part that's still just stunning to me. Why I believe that Judge Glanville, I don't believe he knows that this is wrong. I just don't believe it, because we're going to hear on the 25th, the show cause hearing, he's going to have to argue about this. He's going to have to argue why this was right. I don't think he knows that this is wrong. I really don't think he does. I really don't get it. So and Lord knows he's done this before. I don't give him the benefit there. I believe he's done this before, where he has had these meetings, again, probably with Love and Hyatt, but even Hilton, but definitely unequivocally with some other prosecutors. And I hate to think that other people might be looking into this as well. But he accused Brian Steele of ear hustling in response to specious accusations and impermissible demands of the court. Undersigned counsel relied on the ethical mandates of Rule 1.6 and the Fifth Amendment right to remain silent, and declined to provide the source of the information in which had been proffered. The court is so biased against undersigned counsel. This right here, I think this is it, where he makes, this might not be it, but he makes a stinging accusation against Judge Glanville. No, this is not it yet. It's coming up though, don't worry. And he's so biased against the court and or Mr. Williams, the court ignored all laws and pursued contempt penalties to attempt to intimidate Mr. Steele, to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and all others. Wow. Let's keep going. The court issued a written order of contempt and incarceration for Brian Steele, imposing the maximum sentence of incarceration of 20 days. That is crazy. I still think that was crazy. Like 20 days for that. And mind you, Judge Glanville still at this point is still not saying anything was wrong. He said the only thing was wrong was that you got the information about the crime that I was committing. That's the only thing wrong. You used some new technology to track how fast I was speeding down the highway. Like, but sir, you were speeding down the highway. Well, you shouldn't be using the new technology. Sir, what are you talking about? It's craziness. No, you know what it'd be akin to? It would be akin to me speeding down the road and my passenger is live streaming me speeding down the road. And on the live stream, it has a tachometer showing how fast I'm going. So it shows you me going 100, 105, 110, 120. And while they're live streaming that, they send it directly to the police. And but Judge Glanville is mad that somebody got this information and gave it to the police. Not the fact that he was actually driving 120 miles per hour. That's not the concern. It's not the concern. The concern is, how did you get the information, police people? How'd you get it? Crazy. The court violated the law by failing its duty to recuse from proceeding over this contempt proceeding. And I think that, and later on, he's going to talk about the fact that not only is he the judge over the trial, he's also going to be the one sentencing. So Judge Glanville is deep into this. And at some point or another, I hate to say it, they need to go ahead and cut bait and get another judge in here, or just go ahead and declare a mistrial with double jeopardy and let it go, because the money's going to be wasted. There's a lot of money that's going to be wasted. It doesn't even make sense, because it's going to appeals. There's no way, shape, or form that you don't already know this is going to appeal. So whatever happens here, 3 years or 2 years or 3 days, whatever it takes to get this case to a conclusion, to a finish line, the next day is going to appeal. They're going to appeal it. They're already writing it, for crying out loud. They already got the template for the appeal already written out. You know it. These guys are beasts like that. Where did it go? Where was I? In such proceedings where the announcement of punishment is delayed, and where the contemptuous conduct was detected toward the judge, or where the judge reacted to the contemptuous conduct in such a manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. So one of the other problems is the show trial, I think it's called a show trial. The show hearing, there's another term to it, is going to be on the 25th. It's in front of Judge Glanville. He's the dude you're the dude that was speeding. Like, you can't be the judge and the witness. You can't be the one that was violated against, AKA somebody ear hustled you or eavesdropped, and then you're the one that's listening to whether or not the person eavesdropped. You can't do it. You can't do that. Something is going to have to change. If you're going to have to get Judge Smith down the hall or Judge Butterfly down the road, you got to get somebody else. You can't be all you. Again, there's another option. Judge Glanville doesn't know this. Judge Glanville has done this a lot, or Fulton County is rotten to the core. Fulton County is rotten to all the way down to Fulton County's got to be either Fulton County is just rotten all the way down to the core, or this is just the biggest, weirdest situation ever in the history of life. I think we already know it is. All right. So he lists a couple of some highbrow pre-K law students don't pay attention to this type of stuff. We jump to the next word, which says here. The court involved itself in the proceedings by joining. Oh, here it is right here. Here it is right here. This right here was such a stinger. The court involved itself in the proceedings by joining the prosecution team and conducting the secret meeting that violated Young Thug's rights. He just called the judge a member of the prosecution. And the fact that it's true is just a stinger. Like that's insane. This created a conflict of interest. Boy, have we not heard that before. Oh my gosh, conflict of interest for the court because its own unethical conduct is questioned. And at the heart of the issue, the court then compounded its abuse of power by presiding over the very contempt hearing where its own rule violations prompted the controversy. You was speeding. You are judging the cops that are calling you out for speeding, and you're determining whether or not what should be the penalty for the cops. Don't y'all think somebody else needs to be in here? Like, just get another judge, somebody. Further, the prosecutor, the court should have recused and allowed the contempt proceedings to be handled by a separate court. Personally, I don't think he should have put Brian Steele under contempt. I don't think he should have did that at all, in my opinion. I spoke with somebody yesterday. The judge could just say, you know what? I thought about it. I went home and prayed and reflected over it. And you know what? Let this go. It's okay. You're going to do what you're going to do. I'm going to do what I'm going to do. And we're going to keep it moving. He could have just waived or threw out the contempt charge. He doesn't have to hold Brian Steele in contempt. He doesn't have to. And now that we know who it is, I don't know if that is even relevant anymore, but which I think is a good point. If you're a legal expert or legal eagle and you understand this, maybe you could explain, does it matter now? Because he wanted the name. He wanted the name. Give him the name. Well, now he knows the name of the person, and we'll talk about it shortly. So does it matter? Is Brian still in contempt? Has he, what did he say? He's purged himself of the contempt? Because now we know who it is. He did tell him technically. He told him in a motion to recuse himself. But he did tell him, sort of, I guess. I don't know if that's right. This is so crazy, man. That's why I like this stuff, because it's such an interesting, it's so different from the way that we live life on a normal basis. If you're not in the legal field or not in the law profession, a lot of the way that we live life is different than this. This doesn't even make sense in a lot of regards. But it's interesting because you're like, okay, this is how they go about making these decisions that don't make sense to us later on. Further, the prosecutor sat mute. And this is kind of interesting. Through all of this yelling back and forth, if you go back and watch those yelling back and forth, Love and Hilton and the other gentleman, they just sat there quiet. They was looking down, typing on their computers, scrolling through Instagram, buying stuff on Zappos, while Brian Steele is getting berated by Judge Glanville. But they knew about it. They were a part of the secret meeting, which I think is very nasty work. That is such nasty work. You're letting this man get derided and attacked, and you knew about it, and you knew it was wrong, even so much that ADA Love tried to get up there and say it was right. And she knew she was wrong. She knew it. Sat mute in court to attempt to interrogate and intimidate another member of the bar who reported a violation of law, also promoted the court's wrongful conduct by asserting that the ex parte meeting was proper, which is totally crazy. If this happened to them, they would not be so cavalier. The court denied Mr. Williams and undersigned counsel their due process rights, and undersigned counsel has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceedings. And Mr. Williams had the right to learn of the facts, of the circumstances, of the of this critical stage of the proceedings that occurred in his absence ex parte. All Judge Glanville has to do is just say, you know what, never mind. We'll deal with this, but you do what you do. I'm gonna do what I do. Bygones are bygones, and he can just take this back because this is going to be a dumpster fire. But I do think this is now, man, mind you, none of this will change the fact that this needs to be a mistrial for sure. None of this changes that. But the whole contempt thing is silly because literally, I don't suspect, in my opinion, my unprofessional opinion, this case is going to make it through the month of June. Because this right here is so bad. The fact that the judge is meeting with, and more than like, man, wait till somebody asks, how long have you been meeting? That's going to be crazy. Imagine during the cross-examine, because right now we're watching Little Woody is the state's witness. Yeah, he's actually their star witness, mind you. All of this shenanigans, all of these hijinks are going on. That's between, they're supposed to be on the same team. So can you imagine when Brian Steele is able to cross-examine Woody? And the first thing he might ask him is, sir, how many times have you been brought into a secret meeting with the Judge Glanville? It's going to go, oh my gosh. I mean, it's almost as if Lil Woody is, I don't know who he's working for. I don't know if he's on the states, the defense. I know he's Team Woody for sure. This is going to go so bad. This is going to go horribly bad. I can't imagine this case lasting into July. I just can't. Let's see what else is going on. The court abused its authority by holding undersigned counsel. I'm just going to say Brian Steele. I'm tired of saying undersigned counsel. The court abused its authority by holding Brian Steele in contempt for refusing to divulge the privileged information and for protecting Young Thug's constitutional rights to due process, rights to a fair tribunal, right to a fair trial, right to be present and effective assistance to counsel. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based upon bias against Young Thug and his counsel and favoritism to the prosecution. I don't know what else needed to be said. He's laying out the case, I feel like, top tier. I don't see any reason why. I don't know where else Glanville's going to go. I don't understand how Glanville is going to make it through here unscathed. I'm just going to say it again. I don't think he's going to make it through this without some level of major egg on his face. This is going to be like a gigantic ostrich egg on his face because he's going to probably get kicked off. He's going to probably get some kind of sanction, some kind of issue go on. People are going to start looking at previous decisions that he's made, so on and so forth, XYZ, ABC. It's going to be crazy. Motion to disqualify, recuse Judge Glanville is timely filed as Uniform Superior Court rule. Mandates that the time of filing of the motion to recuse shall be no later than 5 days after the appellant first learned of the grounds of disqualification. The Honorable Superior Court of Georgia has taught that the motion, okay, we're not going to read all that. So basically he's saying, look, we had a time frame and we met the time frame. We did it within 5 days. I think they did it within 3. So it might have been like within 10 minutes because I'm fully convinced they already have these things written up. I'm sorry. They're so well done. I almost believe they have them written up in a file just ready to hit print as soon as something goes on. Because this right here was literally delivered at 4:59. There's no way you're going to tell me that you didn't already have this written out over the weekend. You didn't take the time over the weekend, Saturday, Friday, Saturday, maybe leaving a little bit of Father's Day and get this taken care of so that you were ready on Monday. And this was chill all day. And they're listening to the interrogation and then bada boom, bada bing. Here, I got a surprise for you right here. Take this L. The record also reveals numerous instances during trial when the judge's behavior appeared to have been biased against Young Thug's counsel and partial in favor of the state. So in here, he's going to break down a couple instances where the judge has shown bias. And those are kind of the hot takes that we've seen on the news. We've seen, of course, on the memes and on social media, where he's yelling at the judge, or he's yelling at Brian Steele, or berating a attorney and making him write a 17-page paper about professionalism and timeliness, all while he's having secret meetings and being unprofessional and illegal. Crazy. I still am offended by if I'm offended by anything, I'm still offended that he has made that man write a 17-page paper about being on time when Judge Glanville stays late constantly. We're going to take a 5-minute break. It turns into a 35-minute break. We're going to take an hour long for lunch. It's 2.5 hours long. I'm sorry. It's so gross. You know it. Whenever he says we're going to take a comfort break, a 5-minute comfort break, you already know, okay, I can run down the street to Chick-fil-A. I can go pump gas. I can go get my car washed real quick. Like, you know that. You know it because that's exactly what's going to happen. It's going to be 35 minutes, 40 minutes. I mean, it's crazy. Now, I understand there's reasons why. Things happen. You go to the office, you start working. I got you. I totally got you. But the fact that he held that man, I think that man was 17 minutes late. That's why he made him write a 17-page paper about professionalism and being respectful to the court. I would have just took the L on that one. I understand, but it wouldn't have happened. I even put the order into Chat GPT, and it wrote a pretty good paper. But I still am like, look, I got stuff to do. I got life. See Millhouse. He gives a lot of examples here. I'm going to jump down here. The record reveals other instances, too, when the trial court wrongfully berated Brian Steele in front of the jury. And that was it, too. He was not only yelling at Brian Steele, and Brian Steele was yelling back at him. And I want to say A.D. Love was in there, too, somewhere. But all of that was going on in front of the jury. So it wasn't, and so that does taint the jury to believe something about you if you see the judge who you esteem as being a right dealer, a fair referee, and you see him yelling at another attorney, then something must be wrong with that attorney, because the judge can't be wrong. The judge got to be doing the right thing. So if he's yelling at this guy must really be off his rocker. This guy must really be out of pocket. So it does present a picture there. And Brian Steele mentioned that in another instance. I don't know if it was exactly in this one, but he talked about how he's doing all this stuff in front of the jury. But when he's called on the carpet, he's quick to put a pause and throw the jury out. Just something to recognize in front of the jury. After a number of such instances, Mr. Williams' counsel, Brian Steele, out of the jury's presence, moved for the judge's recusal and sought a mistrial on the grounds that the judge had shown a lack of objectivity, had displayed bias against Young Thug and Brian Steele, and had assisted the prosecution in making their case before the jury. And we've seen that. We've seen Judge Glanville not take Little Woody. Like when Little Woody said he wanted to fire his attorney, he didn't just take it. He asked him more questions. He dug into it more. No, the man said she fired. He said that. So therefore, just take it and leave it alone. No, he just kept going. And I've seen that in other instances also. Judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before him. In this regard, a trial judge shall avoid all impropriety and appearance of impropriety. The Code of Judicial Conduct provides that judges should disqualify themselves in proceedings in which their impartiality might reasonably, and here it is, reasonably be questioned, including but not limited to the instances where the judge has a personal bias or prejudice concerning a party or party's lawyer. Within the context of this requirement, the word should means shall. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, the prosecutors must effectively and ethically present the state's case to a jury. At the same time, the trial judge is charged with, and we'll continue in a second. All right. With that the rules of evidence and procedure are followed, that the proceedings are both orderly, ethical, and fair. When these several interests come together in the courtroom during a trial, disagreements between the bench and the bar are to be expected. The instances discussed above and in the attached example B, and we're going to jump to that in a second, joint affidavit, however, represent more than mere friction between a zealous counsel and a diligent jurist. The judge's conduct, as discussed above and herein, created an impression that he harbored an inclination to be biased against young Thug and his counsel and partial toward the prosecution. Higher courts need to not decide whether such bias and impartiality actually exists, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he has a personal bias or prejudice concerning a party or parties lawyer. I think that's fair. I think it's more than fair to say that Glanville has demonstrated that he's partial against young Thug and this defense team. But let's continue. As explained, the trial judge in the case participated in ex parte communications with the prosecutor in which he assisted the state to influence the witness to testify against young Thug. And we heard that in the breakdown of the secret meeting. These actions certainly raise reasonable questions concerning the judge's partiality and bias, because the trial judge's impartiality is reasonably questionable. It is an error to deny young Thug's motion to recuse. I don't see any way he can make around that. I mean, I don't see how else he can dance around that. Let's go to 17 and then we'll see what y'all think. Our higher court has set forth at least 3 circumstances in which recusal of a court is necessary on the grounds of mere appearance of bias, even in the absence of evidence of the actual bias. I don't know what that means, because we heard this during the disqualification hearing, that there's an appearance of it, but we don't have evidence of it. When you have some evidence, like, what do you mean? All right. Young Thug does not waive that actual bias, has been objectively shown throughout the trial, as well as on June 10th, 2024. But for simplicity, the appearance of bias is also met. 2 of those circumstances also arise in the case at bar. All right, we'll keep this moving. Let's go. Why is it doing that? All right, we're going to blaze through these very quickly. First, mere appearance of bias requires recusal of the judge when the judge becomes embroiled in controversy with one of the litigants. I think we have that. Ladies and gentlemen, I think we have that. And he's going to give the example in example B. We're going to jump to that. I'm trying to get all of the... Oh, I see it right here. Okay. So he gives right here in 19, he's just breaking down several other cases that explain once the court gets embroiled with a litigant, the court needs to be kicked off. So let's keep going. Number 2 or 20. Second, due process requires recusal of the judge when the judge takes a role in the accusatory process. And good gracious, man, I have no idea how he's going to get out of this. All right. Our higher court explained that the Constitution prohibits a scenario where the judge orders a witness to appear before him, her, in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge presides over the contempt trial. So this is another reason why what Brian Steele saying that, look, Brian Steele has an issue with Judge Glanville. Judge Glanville is going to take that information and determine how to punish Brian Steele. That's crazy. There needs to be a third party, somebody that's outside of these two. So it would be Judge Glanville holds Brian Steele in contempt. Judge Glanville and Brian Steele go before Judge Butterfly or Judge Caterpillar, and then they break it down, and Judge Caterpillar determines what happens between the two of them. Not just so it needs to be a three-way. You need an uninterested party is, I think, the term. It's fair to say that Judge Glanville is extremely interested. Okay, let's keep this going. This is because such a judge grand jury agreement cause the judge to become part of the accusatory process, and thus the judge must be recused from further dealings in the case. Here, Judge Glanville has ordered Little Woody's lawyer and others to appear to give information on contempt proceedings. Same is against the law. We got it? Again, he gives in verse in part 21, he gives a breakdown of some court cases and lots of big brain stuff right there. Recusal, number 22. Recusal is objectively required when the judge serves both as the accuser and the adjudicator in case Williams versus Pennsylvania. And that is, he's basically calling you a member of the prosecution. In the case at bar, the court met ex parte with the prosecutors and sworn witness Little Woody, and never intended to reveal the ex parte meeting had occurred to Young Thug or his counsel, which I think is very interesting. Would he have announced this? I can't imagine that he would have. I just can't imagine he would have said, we met this morning. Because if I remember the chain of events properly, they were having the secret meeting around 8 o'clock to 9:30, whatever. I don't know. Something like that before court started. And then court started and got kicked off, and Brian Steele announced that around lunchtime. So I don't know if Judge Glanville was ever going to say, by the way, I met with Little Woody and the prosecutors this morning, and we talked about how to bake banana bread or something. I don't think he would have done that. And I think Brian Steele is right here. The court has become a part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this secret meeting and sitting silent while the court held undersigned counsel Brian Steele in contempt and failed to reveal that any Brady evidence from the meeting, which I think is just sinister. And I agree with them. They could have said, hey, this is what happened and broke it down, but they didn't. They didn't reveal anything. And I think that is really problematic. Any Brady evidence from the meeting, including the fact that the meeting occurred. The court and the prosecutors should not be working together, but they are teaming up to gain an unlawful advantage over Young Thug. Young Thug's trial is constitutionally fractured, unfair, and lacks all constitutionality, statutory and ethical safeguards, and protections of due process of the law. The court is biased against the accused and his counsel. Man, no intellectually honest person could believe that coerced witness Little Woody to testify as a star chamber setting meets constitutional muster. And this is the sentence I think really brings all of us into it. When he says no intellectually honest person, he didn't say no legal professional, no paralegal, no judge, no attorney. He just said just not an honest person that's thinking, that's looking at this and thinking, would think that Little Woody is giving because Little Woody didn't want to testify at all. And they coerced him to do so. So I think Brian Steele crushed it. The court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, biased, partial, potential sentencer, and thus must be removed from the case in toto instanter. Right now. Rhema. Right now. Wow. Brian Steele was not playing games. Okay. I'm going to jump, and I would ask if the moderators could drop this link down in the description for everybody to kind of cop a copy of it. I dropped it last night. I think it's even in the description for last night, but I'm just going to run through here very quickly. Okay, so here is Exhibit A, and this is Brian Steele's initial contempt on the 10th. All right, so this is last Monday. I'm not going to read through this because we all read through this. We're going to go through Exhibit B because Exhibit B is where the smoke is. So I appreciate you all so much. Looks like almost 170 of you all are watching this with me. Good morning. Good to have y'all. Hopefully you have a good cup of coffee or whatever like that. Hopefully you had a good time in the chat. I'll be jumping in the chat in a second, see what you all are talking about. But I do want to say, if you do like this type of content, feel free to hit that like button. It doesn't cost anything. It lets me know that you find value in this and you're enjoying what we're talking about, which is ultimately what I like to hear. And then also jump in the chat. You're part of the best live chat on the planet. That's your pass for entry. Let's keep going. Let's go. Exhibit B. Woo. This is a step-by-step, and he is not playing games. All right. Joint affidavit of Brian Steele and Keith Adams, Esquire. We are over the age of 18 and suffering from no legal disability. We make this joint affidavit based upon our personal knowledge. I have no idea why they have to explain how old they are. I don't know if they like Little Woody. They got to tell you how old they are. I have no idea why do they do that. I think it's hilarious, man. I think this whole thing is, in my opinion, is just some fantastic theater. I'm enjoying it a lot. So let me just make this a little bit bigger. I'm going to read it over here. Oh, yeah. All right. We are the counsel of Young Thug in the above styled case. Now, I do think it's interesting. Like I said, Young Thug has 2 attorneys. So at one point, there were 28 defendants. Can you imagine if each one of them had 2 attorneys? That would have been bananas, man. Let's just say, man, that would have been like almost 90 people just on the defense. On the defense side. Man, the whole courthouse would have tipped over. That's crazy. On June 10th, 2024, and thereafter, offendants learn of the following events and facts that occurred outside of Mr. Williams' presence and outside of the offendant's presence and in star chamber-like environment. I don't know why they call it star chamber. I don't know what that is. I might have to look into that. I wasn't certain what star chamber is. Sound like something from Marvel or something. A star chamber. Make sure this works. Okay, cool. All right, let's keep this dance. On Monday, the undersigned appellants, specifically Thug Brian Steele, YSL Steele, whatever y'all want to call him, asked to have a transcript of whatever conversations were memorialized and the offendants. Let me real quick change this on my end. Sorry. All right, let's see. Memorialize and the defendant's request for the actual recordings of anything discussed at this improper in-chamber meeting on the said day. I just think it's funny, man. Steele really thought, Glanville really thought he was going to get away with this. That's why I believe he's done this before. He's had to have done this before. This court has obstructed Young Thug and below offendants from having an exact image of what was said. The obstruction alone shows that this court is biased, as there is objectively no privilege in communications in this court's chambers, as this court argued on June 10th. And like literally he said, like, this is a private meeting. Like, how does that work? What did he say? It was a proprietary meeting. Like, dude, are you kidding me? This is not protein shake, my guy. You don't have proprietary blend. You don't want to get to do that. Chamber, as this court argued on June 10th, and there is certainly no attorney-client privilege under any stretch of the imagination in this court has asserted. This obstructionist conduct by the court shows bias, and that this court is irrevocably intertwined in the facts of the case and preventing Young Thugs from due process, fair trial, effective assistance in counsel, right to know every material and critical happenings of the case. Further, this court, by its words used on the record when speaking in the open court with the felons, as well as with the court's silence, as well as with the lawyer's statements in open court, clearly demonstrates that the facts below are true and accurate. So Glanville didn't say, yes, we had, well, I mean, he did basically say they had a secret meeting, but Attorney Love got up there and argued that the secret meeting was legal. So you're arguing that something happened that he's saying shouldn't have happened. So by saying this, you are affirming that it did in fact happen. So I got what he's saying there. The court has also silenced witnesses by improperly issuing a show cause order for contempt, and thus, that's what's called, show cause order for contempt, and thus making all witnesses in fear of going to jail if the truth is told about the improper violation of Young Thug's constitutional rights to be present at every critical stage of the trial, fair tribunal, effective assistance of counsel, due process under the law, the right to make records of the case. In the case, this court is biased and must be recused. Further, the cross-examination of Mr. Woody, of Little Woody, will include facts that occurred in this case in the Star Chamber meeting, which puts the credibility of a lawyer Hilton, and this court an issue, and this court should never be the person who is in charge of the jury when the court's conduct is being questioned based upon the courts and lawyers for the state of Georgia's actions. Mr. Williams, Young Thug, has been put into a trick box by the misconduct of lawyer Love, lawyer Hilton, and the court. This court must be recused. A mistrial declared barred by double jeopardy based upon the prosecutorial misconduct and judicial misconduct. What do you do? Glanville, just let it go. Glanville, just let it go, my guy. I don't know what else to say. Like, I can't find a way to be sorry for the guy, because it seems like he's put himself in the trick bag. I never heard it called a trick box. I like that, though. He's put himself in a tricky, sticky situation, shall we all say. And in my opinion, it's a mess. Like, there's no way around it. There's no way to make it better. Let me see, like this. Okay. Let's see if this maybe looks a little better. Hold on. For everybody. Can I zoom in? I can. Look at this. Oh, hold on. We got you. I got you. Oh. We got you, team. Okay. That's a whole lot better, Jason. Get out of here. And it scrolls. Get yourself up out of here. Oh, now there's two of me, though. I don't know how that happened. I might even get a thumbs up for that. I might get a thumbs up or two for that. What y'all know about that? Help your boy out. All right. There we go. I see the thumbs up. Let's go. Let's go. All right. Y'all, I'll be struggle streaming over here sometimes. I ain't even lie. Man. Boy, come on. I think my coffee must be kicking in. All right, let's get this going. Let's go. Mr. Copeland, y'all know who Mr. Copeland is. That's Little Woody. Now, I will say this, though. Even if this trial is thrown out on its ear, okay, I think we all can agree we need Little Woody to run for some kind of state office. We need Little Woody. Like the world, Little Woody is the hero we did not know we needed. He's not the hero we deserve. He's a hero we did not know we needed. So that being the case, we need Little Woody. Little Woody, a witness who had been called by the state and sworn in on Friday. They really want to make sure they drive that point home, that Woody was already sworn in. So as a sworn in witness is different than before you become a witness. So if you ran into Little Woody Thursday night at Subway, that's different than when you run into him Friday afternoon over at the Starbucks. It's different because he's a sworn in witness. So, and who invoked his Fifth Amendment and was held in civil contempt by the court, was brought to the Fulton County Courthouse on Monday morning, June 10th, unbeknownst to appellants, Young Thug, or anyone else on the defense side of this case. This court met in chambers with Little Woody, his counsel, Lawyer Love, and the lawyer Hilton, and at times court reporter Weaver, as well as sheriff deputies and other persons. He telling all of y'all about to get called out. And wait till you see his new witness list. Brian Steele was not playing games. There are games, and then there's what Brian Steele is doing. They're not the same thing. Deputies may have been instructed to turn off their body cameras. There was and is nothing privileged under law about this improper secret meeting. This court and others met with Little Woody for a lengthy period of time. The total ex parte meeting lasted more than 1 hour, approximately 2 hours, with the above named people at the meeting at all or various times. Mr. Copeland, Little Woody, continued to make known his assertion that he would not testify, even in the face of being held in contempt, in order to testify under use immunity. This court and lawyer for the Fulton County District Attorney's Office, Love and Hilton, ignored Little Woody's decision and continued to declare that Little Woody, that he would be held in custody. Listen to this. Until he testifies, or alternatively, if he persists to refuse to testify, he would be held in custody until not only Young Thug's current trial resolved, but until all 26 indicted persons' cases are resolved, whichever is longer. This court was a participant and was present during these admonishments and threats to Little Woody. This is witness intimidation. I don't know what you would call it. If that's not witness intimidation, I would love to know what is. If you tell the witness, if you don't testify, I'm going to keep you in jail until we get tired of you being in jail. I'm going to keep you in jail until we let you out of jail. And that could be next Tuesday. That could be next year. That could be when your kids graduate, when your kids' graduate from college. Which one is that? Is not intimidation? This is crazy. Witness intimidation, coercion in the court has become a member of the prosecution team in assisting the prosecution to induce a material witness to testify. This court, lawyers Hilton, lawyers Love, are now all witnesses in the case. This is crazy right here. This is bananas. So now Judge Glanville is a witness in his own trial. Make that make sense. Was it worth it? Gee, was it worth it, sir? in this case and will be called. You will be called. You will be called. Shots fired. Let me get the shots fired. You will be called by Young Thug and or possibly all accused so that the jury can determine demeanor and credibility of what occurred in this in-chamber meeting. Please note that the witness list is hereby amended by this joint affidavit to include the court, so Judge Glanville, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding the conduct, words, and actions of this ex parte communication. This is crazy. This court provided Mr. Young Woody. It's early, but it's late. I'm on point, but I'm a little dull. The court provided Little Woody with a written copy of the statutes of the crimes of perjury, as well as false swearing. This is no subtle gesture and one that helped the prosecution team obtain the mission of Mr. Copeland to change his mind and testify. That is probably why Monday he was so cantankerous. He's been so difficult. I'm sorry, when he came in to testify initially, he was so difficult back, was that Tuesday? I think that's why. Because he didn't want to, and he knew that he was being held. These people basically told him they're going to hold him in jail until they decide to let him out. Yo, just the thought that we can keep you in jail indefinitely while you look at the Fulton County Jail is is packed. That's so grimy. Oh, that's so grimy. Y'all, please, Courtney Kramer, please jump on that. How many men, how many women are in the Fulton County overcrowded jail right now because of some kind of shenanigans like this? Oh, you don't want to testify? You just sit in jail until the case is over with. Oh, you don't want to give me your testimony? Enjoy your time in jail. I'll come get you when I'm ready to get you. Are there people like that? Because, I mean, that's where Woody would be. If this had happened and played out like they wanted it to, Woody would be in Fulton County Jail or somewhere. He'd be in, I'm just going to say Fulton County Jail, because that's the jail that's overcrowded here in Atlanta. Is it possible that there are men in there that are being held for this kind of stuff? And because the trial is in appeals and because the trial is taking forever, basically they're just stuck there. Lawyer Love made representations to the court in front of Mr. Little Woody and his counsel, sheriff deputies, and the court reporter, and others that Jonathan Melnick, Esquire, counsel for Little Woody, committed misconduct during the representation of Mr. Little Woody and was not representing the interest of Little Woody. These are knowing misrepresentations by the Lawyer Love to the court, which Lawyer Love continues to do, which biases the court in favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitting Love to speak ill of Little Woody's counsel in front of Little Woody adds to the coercion and witness intimidation. Wow, so Love was dissing Melnick? I tell you, man, this has got, I don't think a movie script could be written that's better than this shenanigans. Now, a movie script will move faster. And a movie, of course, is, 2 hours long. But this right here is some craziness. The ex parte discussion violated Mr. Williams' Young Thug's constitutional rights pursuant, and we've already talked about this. We know that. They violating laws left and right and center. They violated my law. They violated me. Oh, wait, what happened? I know one thing. 2, 3 right here. Right there to the top, Jason. Come on. Y'all stretch your hands toward dear Will Christian. Pray for your brother. All right, so As asserted in a motion to recuse, this court filed on 10:40 p.m. on June 14th, Attorney Bumpkus, by her own counsel, verified the below facts. These facts are adopted into a felon's affidavit as below. These facts are assertions of Attorney Bumpkus and statements of her lawyers. So we know that Brian Steele got this information from Kayla Bumpkus. Shout out to her. I think personally, she walked in there and said, what the world is this? Wait, what did I get drug into? She was just there as a substitute teacher. She was just there like, look, I'm just here to help a friend out, ask me to cover for him while he's on vacation. And then she walked into this foolishness. I can't imagine that. Okay, so here is the breakdown of what happened from Kayla Bumpkus by way of her attorney in Brian Steele's example B. On Monday, June 10th, at approximately 8:30 a.m., Little Woody and his attorney Kayla Bumpkus, who is a personal injury attorney. She's not a defense attorney, but that's beside the point, were escorted to the court's chamber and conducted an ex parte meeting regarding whether Little Woody would testify. These present for this substantive portion of the ex parte meeting were Judge Glanville, Little Woody, Attorney Bumpkus, Lawyer Love, and Hilton. Members of the court's security staff, deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. Wow. I wonder who the 2 investigators were. Interesting. All right. In chamber, this court asked Little Woody whether he was prepared to testify. Little Woody announced that he planned on, again, to invoke his Fifth Amendment privilege on the stand. So this is Monday. He had done that on Friday, the first time, when he pleaded the Fifth based upon his age. So he pled the Fifth, and he said, I'm going to plead the Fifth again. Let's keep going. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity, how Mr. Copeland thought he may testify if he did not invoke his Fifth Amendment, and certain facts in the case. Once Mr. Copeland, Little Woody, learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed. So they're already telling you, like, hey, you can just go ahead and give us what we need, or you can sit in jail until we come and get you. That's crazy. Mr. Copeland decided that he would testify. Mr. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. He just said, I'm about to lie to y'all. And they were okay with that. Now, granted, I don't know, based upon what we saw yesterday, the interrogation, I don't know which one is right. I ain't gonna lie. It's a lot of moving pieces. But the man just said he's going to lie to you. The court never assured that this Brady evidence would be revealed to Young Thug or his counsel, and Brady evidence, including the fact that the meeting occurred. Instead, this court takes the position that no information about the meeting should be revealed to Young Thug, his counsel, or anyone outside of the Star Chamber where same occurred. This shows that the court has become a member of the prosecution team in an effort to thwart Young Thug's constitutional right to a fair trial, fair tribunal, due process, the right to be present at each criminal stage of the proceedings, right to call witnesses, right to present defense, right to cross-examine witnesses on critical topics, including the facts of the case were discussed with the court during the intimidation of a witness. That's crazy. This is crazy. This court must be recused. The court and the prosecution, and the prosecution have violated Young Thug's rights, and the indictment must be dismissed after a mistrial is declared, as the court and the state have goaded Mr. Williams into moving for his mistrial recusal of this court. All right, on Monday afternoon, this is when the proverbial stuff hit the fan. At approximately 1 o'clock, once a felon's made the above known in open court, like, how did they know this? How did she pass the information? I want to know. In open court, the court refused to release the transcript of the improper ex parte occurrence, held Mr. Williams, Young Thug's lawyer, in contempt of court, ordered Young Thug's lawyer to serve a maximum period of time in custody for contempt, all in an attempt to intimidate Young Thug and his counsel from understanding and learning about the court's and the prosecution's wrongdoings. The court has become a material witness because undersigned counsel has the right for the jury to understand that this court met with Little Woody and the prosecutors in order to convince Little Woody to testify against Young Thug. Wow. I don't know another way around this. That improper private meeting, y'all. Jason, if you can't get this right, Jason, I think we might have to fire you, Jason. We're going to fire you. Okay, we're going to scroll up. Okay. Where were we? We're on 3, so now we're on page 4. And then we're going to top of page 4, Jason. The law of perjury and false statements and discussing facts in the case is unforgivable. This is not an ex parte meeting that the court has had with felons ever. On the very few occasions that felons have had an ex parte meeting, or rather hearing with the court, a felon announced in open court that it needed to speak with the court ex parte. There was no objection by the prosecution, and the same occurred. Never was a witness involved in these rare ex parte meetings. Offendants demand to question the court and above lawyers for the district attorney's office as to how many ex parte hearings they've had and the substance of these meetings, who was present and the like. Even if just one ex parte meeting occurred, as did on June 10th, this mandates that the court has forfeited its role as an impartial judge and has become a member of the prosecution team. The court must recuse itself. I don't see any way around that. I mean, Brian Steele is not wrong. The court, on at least one occurrence, has been fed improper ex parte information about the facts of the case and witness statements about the recusal to testify. I think I remember this, if I'm not mistaken. It was one of those big shouting matches back and forth with Love. Had said something about, I think this is it, had said something about Brian Steele ex parte and brought it up in court, and it was wrong. The court met with the witness and spoke with the witness about the witness's willingness and non-willingness to testify along with the prosecutors, and then held an undersigned counsel in contempt with the undersigned. We already talked about this. The court has now placed a lawyer for Little Woody and other unknown persons in the position that they need to come before the court on the date certain to give testimony as to who gave information to a felons or affiants concerning this improper June 10th Star Chamber meeting with Little Woody, the prosecutors, and the court. The court has become the executive branch conducting an investigation as a grand jury prosecutor. This court has lost all impartiality, and Young Thug cannot receive a fair trial, with this court being present for the proceedings. I mean, that's it. That is it. This court has falsely and wrongly accused affiant, specifically Brian Steele, YSL Steele, Steele the Thug, whatever you want to call him, of being unprofessional and unprepared in front of the jury. I think this is it. I'm sorry. where they were yelling back and forth. Neither claim was close to truth or accurate. The prosecutor sat silent as affiant was wrongly and falsely accused of improper conduct. This court has violated every neutrality and impartiality that it was sworn to undertake. I'll skip over that. Even knowing that the court has falsely accused Brian Steele of being unprofessional, unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. Yep, that was the whole shouting match between Judge Glanville and Brian Steele. This clearly shows that the court is biased and impartial against Mr. Williams, Young Thug, and his counsel, and in favor of the state, and has no fair judge would be correct in such a serious misstatement made in front of the jury. The bias of this court is objectively proven. When Little Woody took the witness stand on Friday, the 10th of June, he refused to testify and was taken into custody in the court. The court knew that as did the prosecution, that Mr. Copeland would, court knew, as did the prosecution. Hold on one second. I tell you, man, I'm going to get it together one day. That Mr. Copeland would refuse to testify in front of the jury, but the court did not reveal that fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Little Woody's refusal to testify in front of the jury prejudiced Young Thug a great deal, and the jury should never have heard Mr. Copeland exercise his Fifth Amendment rights. I never thought about that. I guess if you hear somebody plead the Fifth, I guess that does make you think something is up. Okay. This jury should never have heard Mr. Copeland exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit the media from filming Mr. Copeland when the court ordered him to be arrested. This direction occurred before Mr. Copeland even took the witness stand. Really? So he had already told the deputies to take and media not to record Little Woody getting arrested before he actually said anything to get arrested? Yo, that's crazy. All right. This court has harmed Young Thug. And then he's going to explain. Young Thug, by hiding this information from Mr. Williams, having ex parte communications with the deputy and media, and permitting Mr. Copeland to assert his Fifth Amendment right in front of the jury, when the Honorable David Botts, Esquire, brought the court's attention that he had evidence that the prosecution knew that Copeland was going to invoke his Fifth Amendment right in front of the jury, this court refused to have a hearing to determine whether the prosecution knew that the witness would invoke his right to remain silent or refuse to testify. And instead, the court had a problem with the attorney Botts. This is backwards. The court has been shown bias against Young Thug, his lawyers, and in favor of the prosecution. This court must be removed from further dealings in this case. The trial must be mistried based upon goading and improper conduct by the court, and the prosecution of another trial is prohibited and barred by double jeopardy. In sum, the court must be recused or the trial declared a mistrial based upon the improper judicial prosecutorial conduct, and that includes, but is not limited to, the court lawyers Love and Hilton are now witnesses because they helped Mr. Copeland change his mind and testify by coercion. Yikes. That's a banger. Hold on. I'm going to get some sound effects on that. The court ex parte assisted in prosecution team by convincing Little Woody to change his mind and to testify against Young Thug. The court has obstructed justice by ordering any transcript of the June 10th ex parte meeting not to be produced to offend affiants to use to partialize this affidavit, as well as a cross-examine Mr. Copeland, the court, the lawyers, and or the state and others before the jury. Facts of the case were discussed by the court at the impermissible ex parte meeting, and the Brady evidence was not revealed to the affiants by the court or by the lawyers of the state. And Young Thug has questions for Little Woody, this court, lawyers in the state, and others about the improper ex parte meeting and how same occurred. Who discussed this fact that the secret meeting would occur and that the substance of the meeting so the jury can decide whether the court and the state have colluded against Young Thug. This is crazy. Wow. This is out of control. So that is Brian Steele's motion that he dropped yesterday. I have no idea how they're going to fix this. I have no idea how they're going to get out of this, what they call a trick box. I like trick bag. But let's see what we got. Kiana calls him YSL Steel. Okay, I got you. I like Steel Gangster, but I'll let you have that too. Good to see so much Caustic Chameleon. Thank you so much. Always good. Let me see if any good commentary. We got Mr. Chaplin in the building. What's going on? What is happening? Hey there, Roxanne Shante. Good to see you. Thank you so much for coming by. Provoke, she said. She said your autocorrect is tripping. I understand. It happens to the best of us. All right, what we got? Terry's in the building. Good to see you, Terry. Always good. Thank you so much. This case is historical, exposing judicial misconduct. Hands down. No question about it. Glanville, I've read your motion and I'm denying it at this time. The appellate court can handle it. Let's take a 10-minute comfort break. See you in 45. That is 100%. That happens at least 3 times. Absolutely, Al. Absolutely. Will we ever see the transcript? Boy, I don't think so, but I wouldn't be surprised. Well, let me take that back. Yes, we will see the transcript. Now, I think if this case goes to mistrial, I don't know if we'll ever see it. I don't know. Do you get to see what happens in a case that was thrown out? I don't know. That's a good question. All right, let's see. What's going on, Sassy and Free? Good morning, Sassy and Free. Good to see you. Good morning to you. Absolutely. There he is. OFAM's in the house, ladies and gentlemen. Good to see you, man. Grace and peace, my friend. 1 coffee down, a Dr. Pepper in hand. Drink of choice checked off. I got you. Retired. Adventures with Red Man Bone. How are you doing, sir? Thank you so much for stopping by on today. Brian still needs his own superhero suit. The Man of Steel. I agree. I mean, he there's some funny names in this case, by the way. And he definitely, hands down, he's a superhero we didn't know we needed. Just for the record, has anybody done the wellness check on Terrence Bradley? Did he just disappear? Sorry about that. That's a good question. Where's Terrence Bradley? Personally, I think Terrence Bradley did what he needed to do, which is stay out of the limelight. That's my little 2 cents. Thank you so much, Kiana. Thanks so much for becoming a member of the channel. Help your brother out. Absolutely. All right, where else we got here? Thank you so much. I see you. Good morning, James Hicks. Good morning. Thank you so much. Salted One says he's way too comfortable. Yeah, Judge Glanville is too comfortable doing this. And that's why I think he's done it before. And I think that's going to come back on him. What do you think about it? Kiska Hamblin, thank you so much. There he is. Morning, Joe. I'm Joe. Good to see you, sir. Always good to see you. There we go. I love that. Always feel welcome in this chat. That's the right thing to do. That's the right response. That's what we like to see here. Absolutely. You know, this is a good point too. So Robin says, while watching those crappy videos yesterday, did anybody else catch Woody saying something about a lawyer while talking to a male detective? I did catch that, and I don't know what that was supposed to, I don't know what the outcome of that was, but I did hear him say that, yes. Yeah, he asked for a lawyer. Somebody said, okay, so it wasn't me. So yeah, and he did gloss over that. I don't, in my opinion, again, I've said this before, Young Thug might be as wrong as two left shoes. He might be as guilty as today is Tuesday. But that doesn't justify you violating his rights and doing shady, underhanded dealings in order to bring that about. If he's wrong, then let him be wrong and prove it. That's it. At the moment, it doesn't seem like they want, it seemed like they're just like, well, by any means necessary, we can prove this guy to be wrong. And he's guilty because we can prove that he's guilty. And he might be just a scoundrel. He might be, probably is. There's probably more truth to it than error. He probably is a low-down, rotten scoundrel. But that does not mean that you get to violate his rights in order to prove that he's a scoundrel. Like, you can't do that. And therein is the problem. But I think we're going to see. We're going to see how it goes, because I think it's going to be pretty interesting as this thing continues. But let's keep going. All right, let's see. That Lato Steele was absolutely a terrific, honest, and attorney doing the right thing. I applaud her. I will give you fair warning. I reached out to her. I would love to interview her and talk to her. By the way, if you know anybody in these situations, AKA Ashley Merchant, Andy Hastings, the Scorpion Queen, any of them, if any of them would like to come on and talk, I will absolutely make room for them. Night or day, early or late, I will make a stream especially for them. So if you happen to know any of them and whatnot, let me know. Let's keep this going. So I don't know. Retired says they are going to say that he didn't actually ask for a lawyer. He just mentioned that he might want one probably. That's probably true. I don't remember exactly the verbiage that he used, but this stage of the game, they're just doing whatever. They're just freestyling. They're just riding by the seat of their pants. They're just doing whatever happens. It happens. I see DD in the building. Good morning. Thank you so much for stopping by. Really? Zanger says the rapper Dark Low got 5 to 7 years for witness tampering. Yeah, why is this not witness tampering? Why is this not? I mean, I know we're using the word coercion and such, but why is this not witness tampering? I wonder why. That's a great point. You didn't mean that. I don't know if you meant me to start thinking about that, but what is the difference between, why is this not witness tampering? And what is witness tampering? Maybe it's defined differently. Good to see you, Queen Fab, in the building. Really glad to see you. Thank you so much. I think I've seen everybody at least holler at all my favorites. And if I did not holler at you, it's because I didn't see you. Let's see what we got. I think we see everybody. I see Anthony in the building. Let me go. Let me scroll back through because I didn't get everybody. Because I see my good brother Anthony in the building. I think, now let me see. SR is in the building. Oh, man. That's why they want to keep Woody on direct until after the 25th hearing about the ex parte meeting. Oh, man. This is okay, that could actually be, man, I need to take a station break to go grab me some tin foil, man. That could be exactly why they're doing this. But, okay, the only thing I would push back on is if they wanted to slow it down, they would let Woody just keep talking versus doing the video. Or try with Woody for another day or two and then do the videos, which would totally push into next week. And then they would, but because the videos are moving faster and they're redacting today. Now, mind you, they're redacting, they got like 15 hours of video. And if they, let's just say they whittle it down to half. So 7 hours of video when the smoke clears. So they come back on, what's that, Thursday? Thursday and Friday, they get done with that. They're going to be into next week and they're going to be finished with Woody. I think you're right. There's something there. There's something there for sure. I can see it. But I'm just wondering how. I would think they would want to keep him on the stand talking. Even if if they're trying to hide it, then they need to let him keep talking. Miss Bumpkins, this is what Charlotte Madison says. Miss Bumpkins has lawyered up and she is going after the judge also. Oh yeah. This is going to be a dumpster fire. We got to come up with another term. This is going to be the biggest bovine scatology, the biggest pile of bovine scatology hitting the biggest fan in the history of ever. Because it's going to be crazy. All right, let's see. I love it. I love it. Good conversation going on here. Dear old Christian, Miss Hilton should have used ChatGPT to word questions for little Woody. It might have done a better job. The bad thing is that you could add to ChatGPT. It would only take a few clips from little Woody to add in a ChatGPT, and you can make ChatGPT actually speak and answer questions like little Woody does. It wouldn't be hard to do. That prompt would not be hard to write at all. Good to see you, Ski Burrow. Good to see you, brother. Oh, no. Yeah, his impeachment is real. Let's hear it for Gackle and the strike team. I want to know more about the Gackle. Yo, if you know any lawyers here that are involved in this, I would absolutely love to interview them. I would love to. Because there's just a lot of questions I have about this. Like one of them is, why is E. Todd in the building? Good to see you, E. Todd. I would love to hear, like, how does the strike team work? How do they know? Okay, I don't think there's actually, to your point, Robin, I don't think there's actually anything going on today. And Kiana can let me know if I missed something. But I think they're just going through the videos and redacting what needs to be redacted. So I don't think that it's anything going on today. Last I heard, there wasn't. Good to see you, Michael Williams. Good to see you. And I'll just double check again. I don't believe there's anything going on. So that's why I said we would just come in and just have a good conversation this morning and go over those two motions. Tough guys in the building. Good morning. Fani is not going to let the death of her side married man, Mr. Johnson, was married out for blood. Yeah, this story right here, there's a lot of, it's got legs. I'll say it like that, tough guy. And if you're not familiar, there's a rumor, there's word, I have not confirmed nor can I deny it, that it's possible that DA Fani Willis had some relationship with the guy, Big Nut, who Peanut or whatever his name is, that was actually deleted is being alleged that he was deleted by Young Thug. That's why this case has had such veracity. That's just my little 2 cents. That's what I've heard. And there's reason to believe I think this is right. So good morning to you, Clemens. Always good to see you. Thank you so much. All right, I think I got everybody. If I did not, Star Chamber is a movie also about a judge starring Michael Douglas. That sounds like a Michael Douglas movie. That title sounds exactly like a Michael Douglas movie. Where is he? Where's Michael Douglas been? And that sounds just like him. Sounds just like him. Definitely sounds like it's from the 80s. Definitely. All right, real quick. Hey, what's going on, Paulus? Good to see you, friend. Grace and peace. So if you're new, you're just stopping by, pity bitty. Hey, everybody. Good to see you. Thank you so much. As well as my sister, Kenya. Good to see you. These black folks are ruining this city. There, I said it. We need diversity. Wait, sorry. There, I said it. We need diversity. You're not lying. What's real time saying? Real time is giving us a little sunshine and smiles. I love it. Nope. You don't have to be. Bitty bitty. Yep. You don't have to be. All right, let's see what we got. Am I missing? Let me see. All right, just looking through real quick before I do have a super chat. I want to thank you all so much for the support. Let's jump over here real quick for that. Let's see what we got over here. It's Independent Mail. Ladies and gentlemen, Independent Mail is back. All right, so helping out with my RICO Defense Fund. I appreciate you. So if y'all don't know, Quentin is a fantastic content creator. He lives here in Smyrna, which is right down the street around the corner from Marietta. And he went out of the country. And he did not call me and let me know that he had made it back. So I told him I was going to start making rumors that I was going to start some rumors about him being abducted by the cartel or something like that. So I'm glad Quentin is back. Thank you so much for the kind super chat, my friend. You know what? Because you're back, I'm going to make you the stream sponsor with the $5 super chat. Let's do that. If I can figure it out. All right. And if the moderators can drop Independent Mail's YouTube channel in the chat, it would be great. All right, we're going to make him the stream sponsor with the $5 super chat. I appreciate you, friend. Thank you so much. All right, let's talk about... All right, I am here for the impending cat fight between Ashley Merchant and Fonnie Willis. I'm here for it. I know it's not really as big a deal as we're making it, but I am here for it all. So what am I talking about? Well, hold on, this is not the screen I want to use. Do it like this. There we go. And I don't know why there's two of me. Are y'all praying for me? Because I got to figure this out. All right. So one of the things here, and most governments are like this, if you're in a city, a municipality, a township, a state, or even the federal government, when you use federal funds or taxpayer money to do something, that usage is public knowledge. And so a media outlet, a watchdog group, an activist group can file what's called a Freedom of Information Act to see how you're using federal funds. So let's say you run the gerbil catcher department for your city, okay? And you capture all loose gerbils and whatnot. And you have a gerbil department credit card that's issued from the state, and those monies come out of the state coffers toward your organization. If you use it to buy gerbil catching equipment, then on the credit card receipt, it would show on the credit card statement that it was used to buy gerbil catching equipment or gerbil food or gerbil cages, whatever, right? However, if you use it to pay your Netflix bill, that's going to be a problem. If you use the credit card to buy a trip to Aruba, there's going to be a problem. And the Freedom of Information Act is meant to allow full transparency. I do think it's a good thing. I used to be a school teacher, and that's why if you have friends who work in certain industries and whatnot like that, and they have a work computer or a work phone, they might be really dogmatic about how what kind of text messages you send them or what kind of emails you send to their work email. They don't want you to send the silly cat picture video or the conspiracy theorist meme to their work phone, because that could fall under freedom of information. Or that can, your email, same thing. Chats, anything on your computer, work computer, could fall under freedom of information and could get you possibly in trouble. You may have heard people get in trouble like this. So that's what the Freedom of Information Act is. One of the things about it here in Georgia, at least, if somebody files, I'm the chief gerbil catcher, and somebody files a Freedom of Information Act against the gerbil catching department, I got 3 days to get that information to them. So let's say they file it today, Tuesday, I got till Friday to get that information to them. or at least respond to their requests, their FOIA requests. Now, where am I going with all that? Fonnie Willis and her very poorly run DA office is now being sued by Ashley Merchant. I'm sorry, was sued by Ashley Merchant because they turned in none of this stuff. Remember I said you got 3 days to do it. They did nothing. They gave her nothing. Now, Jason, why did you say was sued? Why did you say that? Well, this lawsuit came back in 2023, well before the initial disqualification hearing even jumped off, well before Terrence Bradley started sniffing the Pantene and all that kind of stuff. This Ashley Merchant was looking for this information, and she was on the trail a long time ago. And none of that stuff was delivered. If you remember during the disqualification, when Fonnie Willis came bursting into the court like a Brahma bull, and Ashley Merchant asked her, you denied our request for your Delta flight records. And Fonnie Willis said, no, you got it wrong. You want to get involved in people's life and blah, blah, blah. That's not the case. This was supposed to be, she wasn't asking for Fonnie Willis's personal Bank of America statement, as far as I know. She was asking for the district attorney's bank statement. I think Fonnie Willis showed her hand that she's using both of those interchangeably. Now, I could be wrong. Maybe I misunderstood what Ashley Merchant was saying or how Fonnie Willis rebutted it. But I think it's fair to say that if Fonnie Willis was flying based upon FOIA, flying for Fulton County business, then that should have been on the Fulton County bank statement. If it wasn't, then that's a whole nother game. If she's using her own personal for her personal trips, then maybe that's something different. Maybe we can figure that out. Maybe that does fall under FOIA. I don't think so, but I think what we're understanding here, and you'll see in a moment, Fonnie Willis doesn't keep good records. And I keep saying this, and I think it's a real easy dunk to make. Fonnie Willis keeps horrible records. She does horrible record keeping. So let's go. Plaintiff's complaint for violation of Georgia's Open Records Act and motion to defendant to show cause. Okay, and this is Merchant Law Group versus the Fulton County District Attorney's Office, because they were looking for this information and they never got any of it. Okay, introduction. We're going to just blaze through a lot of this, but I will ask that the moderators drop this down in the chat as well. I'll put it on my Buy Me a Coffee page as well so you can download it. It'll be free, of course. Georgia's Open Record Act, and they give you all the important information, is the important mechanism by which citizens of Georgia are able to evaluate their government's use of resources. The Georgia General Assembly explained the purpose of the act as such. The General Assembly finds and declares that the strong public policy of the state is in favor of open government. The open government is essential to a free and open democratic society, and that public access to public records should be encouraged to foster confidence in government. And so, what happens? That the public can evaluate the expenditure of public funds and the efficient and proper functionings of the institutions. The General Assembly further finds and declares that there is a strong presumption that public records should be made available for public inspection without delay. This article shall be broadly construed to allow the inspection of governmental records. Now, I bring this up also because this is also what Jim Jordan was asking for. Now, Jim Jordan was asking specifically because it was a part of a grant. And so even in a grant, there's actually even greater transparency than just the Freedom of Information Act. But again, I think you all see the point is that governments should have records and should be willing to quickly divulge where those government funds, again, taxpayer funds, are going. Let's keep going. The expectations set forth in this article, together with any other expectation located elsewhere in the code, shall be interpreted narrowly to include only those portions of records addressed by such expectation. Okay, so we see pretty clearly this is the expectation of what's going on. And I'm gonna scroll down to where the actual complaint starts. All right, right here, I think it's 4, right? Oh, it's 3. No, I guess it is 2. I'm sorry. I guess I didn't go anywhere after all that. I didn't even go anywhere. Thus, the public policy behind the act is encouraged transparency in government, and there is a strong presumption that the public records it be made available to public inspection without delay. As the Georgia Code, and it just said that, the ORA, I don't know, why is it called the ORA? Open Records Act, okay. The ORA, Open Records Act, was enacted in the public interest to protect the public, both individuals and public generally, from closed-door politics and the potential abuse of individuals and the misuse of power such policies entail. Therefore, the act must be broadly construed to affect its remedial and protective purposes. The intent of the General Assembly was to encourage public access to information and to promote confidence in government through openness to the public and allowing the public to evaluate efficient and proper functions of its institutions. I feel good that that's laying out a good case, so let's keep going. District Attorney Fonnie Willis has made public statements indicating that she would lead the Fulton County District Attorney's Office with a stated goal of being transparent with its citizenry. All right. She said that back in 2018, 2019, she was running against Paul Howard. She said, transparency and integrity. Gotcha. Let's keep it going. Let's go. Despite the General Assembly's clear intent and Ms. Willis's statements supporting transparency, however, the Fulton County, the FCDA has denied plaintiffs the right to inspect a number of FCDA records. Some of these records include reports provided to FCDA by third-party media companies that were hired with taxpayer funds to track impact of Ms. Willis's statements to the media and whether such statements were viewed favorably by the public. Ms. Williams first began contracting with these companies just before she and FCDA sought to investigate and indict Mr. Roman and other co-defendants in this case, she gives a number, currently pending in the Fulton County Superior Court. As shown more fully below, FCDA is the clear violation of the act, appears to be intentionally withholding information in advance of scheduled evidentiary hearings in 2 separate proceedings. So the infamous disqualification hearing had not happened. This was just a proceeding with Mr. Roman and the rest of the Trump trial, the election interference people. So the infamous had not even taken place yet. So matter of fact, she's on the hunt for it. She's definitely aware that something was going awry, but Ashley Merchant had not even begun to put together the X's and O's that she hints on it later on. These are not the efforts of an agency that values transparency. The plaintiff requests that the court grant the relief request herein and find the FCDA must permit inspection and or copying of numerous categories of documents that will have not been made available to plaintiff. It is evident that FCDA has withheld the records without substantive justification under the state code. Okay, so they've been asking for records, which they're required to give because of ORA, the Open Records Act, and they've not been getting them. All right, let's keep it going. The court has jurisdiction over the subject matter of this action pursuant to, and they give the deep information, which notes that the superior courts of the state has all jurisdiction in law and equality and equity to entertain actions against persons or agencies having custody of records open to the public under the article to enforce compliance with the provisions of this article. This court has personal justification over Fulton County because Fulton County principal place of business and operation is located in Fulton County, Georgia. There we go. So she's asking for the court to require and demand that Fonnie Willis gives up the good information. She gives several reasons why that should happen. And so now she explains who are the parties at fault right here. And I'm going to kind of give a summary of it because I do want to get to the fun part, the factual background. Plaintiff, and this is the Merchant Law Group, is the plaintiff, represents Michael Roman, a defendant of the Fulton County Superior Court criminal case. They give a number there. An evidentiary hearing is scheduled on February 15th, 2024 on Mr. Roman's motion to dismiss the indictment to disqualify Fulton County District Attorney Willis and the special prosecutor Nathan Wade from further prosecution of Mr. Roman in the case. Mr. Roman has subpoenaed Ms. Willis and Wade to testify on the 15th hearing. Furthermore, Wade is scheduled to appear at a separate evidentiary hearing in his pending divorce matter tomorrow. So that's when all of this hit the fan. Among other grounds, Mr. Roman has asserted that Ms. Willis and Wade should be disqualified because Willis used taxpayer money to pay Wade, with whom she has had a romantic relationship at the time, and in turn has received financial benefit from such payments in and from vacation, hotel stays, and other personal gifts. In light of this information, Mr. Roman believes that Ms. Willis has use of money budgeted for Fulton County is of utmost importance evaluating whether Willis and Wade have an irreparable and fatal conflict of interest, and whether and to what extent Willis has otherwise used public monies for her personal gain. It is apparent that the effort to intentionally stall plaintiff's inspection of various categories of documents prior to the evidentiary hearing in this matter, FCDA, or rather Fulton County, has refused without adequate explanation to provide plaintiff with many of the requested materials that are known to exist and which are not subject to any exception in the act, and some which have been outstanding since September 2023. And later on, she goes through like the full breakdown of when she gave the request and what was their response. Let me move this out of the way. On September 1st, 2023, plaintiff by Thorough shareholder Ashley Merchant requested certain public records by the Thorough Fulton County Public Records Center electronic portal pursuant to the act, which was assigned to request number. There it is. And this is what they got back. Any and all bids, contracts, and agreements for the appointment and payment of following contractors with Fulton County. They want to know about the law offices of Nathan Wade, Christopher Campbell, Cross Firm, Anna Cross, Bomburant, Mixon, and Elmore, and Terrence Bradley. There goes Terrence Bradley. All right. These are those no bid contracts that they were talking about there. And I'm seeking in their invoices, contracts, county approval of their vendors, and any other documents regarding the contracting and payment of these vendors. And I think during the disqualification hearing, we heard that there really wasn't, they just gave them these contracts. There was no bid in there. There's no transparency, if you will. It was just, hey, here's some work. You want it? Let's go. A copy of the September 1st request, along with all the following up correspondence associated with the request, is attached hereunto collective in Exhibit A. All right, so what I'm going to do is I'm going to scan down. I do want to let you know that this is a long piece. They're very thorough over at the Merchant Group, and I think that's dope. I always like when people take the time to explain out what they're doing. But, so not to be terribly long, we're going to just kind of blaze through this real quick and get to Exhibit A, where she kind of breaks down all of the nuances. And it's about, if I'm not mistaken, this is like 27 pages. So we are a little better than half way through. And I will leave this available for you to pull up and go through yourself. I don't want to read all of it, but I do want to get to some of those exhibits that they asked for. Okay, here we go. All right. Okay. So here's where she went through the public records portal, and you got the public records. This is what they were asking for, and this is the information that they were looking for specifically, and they're not getting any replies back, and things are being shut down before they even being considered, and they're taking way longer than the 3 days that they're seeking it. So I'm seeking copies of all of these bids, contracts and agreements, and the appointments and the payments of the following contractors. And she explains fully right there. So now you go through the electronic portal, you request this information. Sometimes there's a monetary, per page type of situation there. And so the reply back that she got was, please log into the portal to see the attached documents. So she asked for these documents. She thought she was getting them. And what did she get? Please log into the portal. Good afternoon. I am just following up to hopefully for one last time. I have not received any bids or county approval of these vendors. Please let me know if that means that these items do not exist, or if you are still working on getting them to me. Additionally, I have not received any invoices for Christopher Campbell whatsoever. Please let me know if this means that there's invoices, if no invoices exist, or if you're still working on them. If you're still working on them, getting these items, please let me know. If they do not exist, please let me know that as well. If I do not hear from you by the end of the day, I will assume that these items do not exist, but please let me know one way or another. That's from Ashley. Good afternoon. I am following up. And again, this is another follow-up, and this is on September 14th. So this was on the 15th. So notice she keeps asking for this information. She was on the 14th. She asked for it. Please let me know the following up. I still have not received any original initial first contact from Nathan Wade. If you would like, I can email you what you sent to show you that you can verify it does not include the original initial contract. We also have not received invoices for Chris Campbell and do not receive documentation regarding the county's approval of these contracts or the bid process for them. Please let me know when we can expect remaining items. If these do not exist, please let me know as well. I look forward to hearing from you. Again, this is another example of how Fonnie Willis's department, now we're going back to the 13th of September 2023, same thing. There were two attachments that contain contracts for Nathan Wade. The first is Nathan Wade, and it is 7 pages, does not contain a 2021 original contract. The second is Nathan Wade 2, and is 4 pages and does not contain the 2021 original contract. The original first contract is not included in the attachments. So even the things that they're sending are incomplete. When they actually sent them something, they sent them information that was not correct. Thank you for sending these invoices, and this is from the 13th of September. Thank you for sending these invoices. We still do not have a contract from Nathan Wade. That was the first contract that was entered into on November 1st, 2021. We have recontracted and the addendum to the November 1st, 2021 contract, but not the contract. So you updated a contract, but where's the original contract? We also do not have the invoices for 2 Terrence Bradley or 3 Chris Campbell. Finally, 3, we do not have any county approval of these vendors or any documentation regarding the bids that the county approved of these vendors and projects. If none of these numbers 4 above exist, please let us know as well. So we can see pretty clearly how often she's asking for what was the vendor process, how did the commission approve, because Fonnie Willis approved it. The commission did not approve of these. It was Fonnie Willis that did. Let's go 9/11. Pages 5 and 7 have those dates listed as the dates prior to the contract, which is pages 5 and 7 for the recontract and the state of on this page 5. They reference the prior contract and say that this has been a recontract. I do not have the original contract. It is just referenced on page 5 and 7. And the dates are provided, but the contract is not included in the materials you sent. Thank you. So they're sending, again, just half done, incomplete data. But isn't this consistent with Fonnie Willis's DA office? I think we could all agree that it is. Let's keep going. And we're just going backwards to seeing this. And on the 11th, again, at 1 o'clock p.m., I received the contracts. Thank you. The contract for Nathan Wade references an original contract that is not included. It would be the contract that began on November 1st, 2021, and ended on November 31st, 2021. Wait, what? That doesn't make sense. And ended on October 1st. Isn't October 1st? May I also have a copy of that contract? Isn't that, I don't know how that works. I don't know if that's a typo or is that some weird math. If the contract began on November 1st, but it ended on October 31st, it's backwards. Maybe the date is wrong. Maybe they meant 2022. I don't know. That's a good question. As far as the invoices, the contracts reference travel and lodging expenses. I just want to make sure those reimbursements would be included. Thank you. So again, we see already there's some shenanigans going on. Lodging expenses, travel expenses. Okay, so these invoices will be released later than Friday, no later than Friday this week. So this is earlier on September 11th. And again, you can see pretty clearly that they're not giving this information. So are they not giving it because they don't have it, or they're not giving it because they never did it? I think is the question that should be at hand. And as we go back through Ashley's breakdown, actually these are, how many more pages? Let me see how many pages this is. Oh no, there's a lot of pages. I'm sorry. Yikes, this is, I'm gonna drop this for y'all because I'm not gonna put this on you. I didn't realize this thing's a lot of pages. Holy cow. Did I miss that? I must have missed that. There's a lot of pages and Jason is not gonna read through all those. But I just kind of want to point out some of the inconsistencies. And I think if you enjoy this type of stuff, you'll have a good time going through this because it is interesting to see how much Ashley Merchant was gracious and kind to ask for things. The Merchant Law Group was asking for things from Fulton County, and they didn't keep up with their records. So either they didn't keep up with their records at all, or they completely and totally botched it up and they don't have them in any kind of order or anything like that. But I think what we all probably understand is that they were completely flying by the seat of their pants and just doing whatever felt good at the time being. There was no rhyme or reason. They were just doing things as they wanted to and went like that. But let's see what y'all are saying in here. Oh my gosh, I'm sorry. There's a lot of comments here. And I'll let y'all get way far. I apologize. All right, let's go. Willie Doc is over there by Fulton County. Go check them out, man. Go stop by and see if they got the air conditioning working today. Good to see Willie Doc, by the way. Thank you so much. A great brother and supporter of the channel. Appreciate him. Did I leave my... Okay. All right, let's see. Thank you so much for the likes. Thank you so much, Independent Mail. Appreciate you, brother. Thank you. Yeah, this is, Connie, this is insane. I don't even know how to explain it, but I don't think, somebody said that they're writing a movie about this. I'm like, no, why didn't he write a movie about it? I mean, literally, it's going on right now in real time. All right, let's see what we got. Dan says, what's going on from Maricopa County, Arizona? Good to see you, Dan. Thank you so much for stopping by, friend. All right, what do we got here? Looks like some good commentary back and forth. Always enjoy the good mornings and the good shout outs from everybody. Thank you, Fran, for that. Thank you so much. You need to look into the 2020 vote to get out of his charges of court. Okay. I got you, Craig. Thank you so much. Let's see what we got. I see some good commentary back and forth. I always enjoy the good commentary back and forth, just checking out what people are saying. Lots of family reunion, as I call it. Looks like a lot of you all agree that there was some shenanigans going on with this Ashley case. As a matter of fact, let me make sure I drop that. If the moderator did not grab it, I want to make sure I put that in the chat for you all. If you're interested in it and wanted to finish reading it or whatnot, because I know I'd kind of jump through it, I'm going to give you we'll start with the no, this is not it. This is it. All right. So I'm going to give you the court case from yesterday. I'll just drop it in the chat real quick. And then give you the Ashley Merchant case as well. Always, if you do have a problem, you can always email management, and management is always here for you. All right, let's see. I apologize. I did not get this for you earlier. I should have had it ready because I downloaded it, but then I didn't have it ready for you all. Sorry about that. All right. All right. I believe this is it. Yep. Okay. Oh, that's Amanda Timpson. All right. And I'm dropping that in the chat as we speak. All right. Thank you so much for that. Let's see if we got any other good commentary going on. Wait, Dan says most of the funding comes from the state of Georgia via the Atlanta Judicial Circuit process. What did I miss? I feel like I missed something there. Okay, y'all talking about extra money. I need some extra money. Where the extra money coming from? Where do we get it from? I need to find out. Don't hold it. Don't keep anything a secret. Come on now. Share. And let me just check something real quick. Oh, no. Oh, there's actually, so they are doing, I see Lead is looking at, what are they doing today? Oh, no. Q, why didn't you tell me something? Are they actually going through the case now? I hope not. Did I miss that? Ay. Everybody, I didn't know that. I thought there was nothing going on today, but looking at Lead's video right now, it looks like there are. There is, rather. Let's see what they got. Oh, okay. It looks. Okay, it looks like lead attorney and them are going through live trial watch Little Woody to testify against Young Thug Day 7. So it looks like they're going over to today. Good gracious, man. This case is crazy. Let's do this. The court addressed Bumkus and Steele's motions. Oh, that's what they're doing? Okay. Are they on break? But I was looking earlier because I didn't want to start this and people were going to be in the middle of jumping between shows. Or jumping between, because I can't keep up with leading now. I can't do that. That's crazy. Okay. Definitely email management if you have any questions, comments, concerns, or complaints. Please let us know. All right, let's do this. Because I just wanted to go over that case. I know lead, and I'm probably going over it now, as well as just adding that good color commentary. So let's do this. I'm going to get ready. After recess, the court will address the Woody video. Okay. So did they say what happened with what they say about the motion from Brian Steele? Interesting. Oh, they were giving play-by-play? I'm sorry. I didn't see it. I'm trying to see what the play-by-play is. I don't see it. I apologize. I didn't think that they were going to be doing anything. That's why I said, let's do this right now, because I figured there was nothing going on. Ay, ay, ay. I did not even see it. Okay. The judge said, I ain't going nowhere. That is hilarious and probably exactly what he said. That is crazy. I don't know. This is a great question. How can he get away with this? I have no idea. Wow. I don't even understand how this even works. Yeah, this is, wow. Look below the police sirens. I don't know where the police sirens are, friend. I don't know where the police sirens are. Where are the police sirens at? Look below the police sirens, play by play. Oh, okay, I got you. Okay. I had to read it out loud. Then I understood it. Look below the police sirens, play by play. I don't see the police sirens, but I know what you're talking about. Okay, I'm going to figure it out. I don't see the police sirens. But I know what you're talking about. I just don't see the lights. But okay, so they're in recess right now. So the judge isn't going anywhere, if I understand it correctly. Oh, there we go. Judge is on the bench. Oh my gosh, I didn't even see this. I'm so sorry, y'all. Judge is on the bench. Judge is on the bench. Motion to recuse by Bumpkus is being dealt with now. Oh my gosh. Did anybody text me? Nobody text me. Oh, wait, somebody did text me. Let's see. It was actually my pastor text me, but it wasn't about this, of course. I wish I had called me. Q, you could have called me. Little Woody would be a hoot. Let me just say that. Oh, you email me too. Ay, ay, ay. My email's closed because I have both my windows open going over this. I'm sorry, y'all. Yep. Y'all are great. And say, judges on the bench. Jason, shut up. I'm sorry, y'all. Please forgive me. Forgive your boy. Forgive me. She emailed me too, y'all. Text and email me. Judge is addressing whether the motion meets the time limit. It did. There's no way around it. Okay. I did not see this. I had this whole window closed out. Y'all, transplanted Texan is serious. Y'all, let transplanted Texan know y'all love her. Put Texas in the chat, because transplanted Texan was gonna let y'all know, was trying to let your boy know, and I was totally asleep at the switch. I'm over here just going to town. I ain't paying no attention. I was my chat window was closed out. I was focused. I was in the zone. Man, I'm sorry. You did the best you could, Texan. It was me. I thought it was me. All right, so court is on 30-minute recess. I got you there, right there. Texan, I'm gonna give you my phone number next. I'm gonna email you my phone number in a minute, because you was crushing it. Texan was trying her best to let me know, Jason, shut up. And I'm sorry. I'm so sorry, y'all. And I saw the RICO thing, but I did not see this. I'm sorry. All right, what we got? Okay, so far, it seems like Judge Glanville shot down Brian Steele as well as Bumpus. That's going to be ridiculous. So let's do this. Let's jump over here and let Lead see what Lead is talking about. And I think it'll be a good conversation. How many people over here? Do y'all want to hear? What are they watching on Fox? Let's see. Maybe we'll do it over here too. All right, let me go. 11 Alive is the one that most people are watching it on, I think. Oh my gosh. That Snapchat ad was crazy. All right, so is 11 Alive the jam? Is that the one that everybody's watching now? I think so. Thank you so much. I was totally focused. I was in my zone. But I do think part of the problem is I need to learn how to better create scenes using Ecamm, because I should not have to use my entire screen to do this. And I use my entire screen, and I should be able to do it differently, but I'm not proficient. So there's a user error problem on there as well. So, all right, so we see that they're not ready yet. So I'll just jump back over here. All right, let's see what we got. Okay, so I'm on 11 Alive. Is that good sound quality one? I would love to know before we even jump in if I need to jump to another one. I think that's the one that most people are on, is the 11 Alive one. So, yeah, man. But thank y'all so much for hanging out. Let's go. Hopefully some good things will come out of this. We'll hear some cool things. I might want to jump back and see what they were talking about. But Judge Glanville said, man, I ain't studying you and your shenanigans, your hijinks. Okay, I'm looking real quick. All right, so it looks like Lee was having problems with Fox News. Is that bad, Q? Watch on long crime trials. That chat has become fam. And Inside the Law was that chat. I'm sorry, what'd you say? Inside the Law was in that chat this morning, dear woke. Okay. So I need to run by there and say what's up, all that kind of good stuff like that. What's going on, Chicky Brewer? Thank you so much. Thank you for being family friendly. I'm glad to do my best to do so. Absolutely. Okay, yeah. So law of crime trials, y'all think is the one? Okay, let's go. Let me have that queued up. Let's see. This is amazing that, an entire cottage industry has come up out of watching court. There's no way in the world, if you had told me that this was on my bingo board for 2024, I would have believed you. There's no way. And now look at me. I'm like scrambling to try to find something. Oh. Okay, sorry about that. All right, what we got here? Okay, so at the current moment, law and crime is waiting just like everybody else is. And I appreciate y'all waiting with me. Let's go. I'm going to send a shout out in law and crime. Hopefully the sound quality is going to be good. All right, let's see. Got you. I'm already there. I'm paying attention now, transplanted Texan. I'm doing my best. Oh, got you, Q. Thank you so much for the heads up. Thank you so much. Yo, the live chat on law and crime is crazy. Okay, I'm gonna bring it in so we can. Live chat is crazy. Somebody over here talking about this. Y'all get your people, get your folk, get your people. This is wild. I still cannot believe that we are watching this in 4K. I just can't believe this. This is craziness. Throw the whole case away. I agree. The whole thing. I agree. The judge, I don't understand how he's going to. He's literally softballing this for a mistrial, hung jury, of course, appeal. He's just literally just setting this up for that. The judge is gone rogue. I don't get it, man. Yeah, this is craziness. So we're going to jump into this as soon as it gets started. Thank you so much for giving me the heads up on that. I apologize. I did not think this was going to be televised today. I really didn't. I did not think it was going to be televised. What are these little hearts for? I want to drop some hearts. What's that do? There. Does that do anything? What is that for, I wonder? All right, so we'll be ready when they come back. But y'all, I appreciate you so much. I did not, like I said, I was just in my zone. I was not even paying attention. And lo and behold, y'all like, Jason, you talking too much. All right, let's see what we got. Mm-hmm. And my shepherding elder texted me. But it was not about this. Telling me to be quiet. It was not that. Wish the New York Trump trial was televised. Think it would have helped people see how bad it was. I do agree, because it was bad. So I can totally rock with that. Totally. Okay, just texting Joel back. I bet there was a lot of discussion behind closed doors. Absolutely. Get your Atlanta Must Be Stopped t-shirt. Absolutely. I think I'm going to put the Dear Woke Christian one on there as well. Let's see. What did Apex say? They got a bullseye. What did Apex say? Wish the New York Trump trial was televised. I think people would have just had helped people see how bad it was. I agree. Oh, that's what that was about. Absolutely. Well, y'all, then I guess we're gonna watch it together then. I'm getting a couple of text messages about some of the language. So I just want to I'm glad that, we keep this as generally speaking, a family-friendly conversation place. So I'll do my best to do that and keep that going today. Hopefully Judge Glanville and them will get back in before they jump in and start doing lunch. So thank you, Terry, for becoming a member. We appreciate you. Thank you so much. I plan to do a members-only live stream on Saturday. I'll keep you posted on that. We're taking Chief Executive Secondborn to school. And Lady Dear Woke Christian and I are going to have the house to ourselves for 2 weeks. So the plan is to still do a members-only live stream on Saturday. All right. All right, let's see there. All right, shout out to my pastor who texts me in the middle of the day to say, hey, that's kind of cool. Welcome to the family, Terry. Thank you so much. I appreciate you. One of the things I do want to, since we're just kind of chewing the fat here, I want to thank you all, of course, for being members and supporters of the channel in the various and sundry ways. I appreciate you all just coming to these live chats, live streams, and just engaging in the content. So though I might be considered the talent, I might be the face of it, you all make it all fun by being in this chat, conversing with one another, throwing out ideas and questions, texting me, telling me to be quiet because the show has started. So look, you all mean a lot. So I really do want to say thank you all for being a part of this and for all the support in various and sundry ways. It means a lot. So thank you again. And hopefully we're going to have a good show on today. We have some good conversation about this. I probably wouldn't have mind hearing what Glanville said as it relates to the matter of fact, let's just do that. While we're waiting, let me know. We're going to do this. I kind of want to hear what he said. So let's do this. I'm going to TiVo it.
How's Mr. Weinstein? Okay. All right. Okay. All right. Mr. Huey and Mr. Matthews, Jr. and Senior, good morning, gentlemen. All right. Mr. Nichols and Mr. Harvey and Miss Westmoreland, good morning. And Mr. Ryan and Miss T. Williams, good morning. All right. Mr. Atkins and Miss Hilton and Miss Knight, good morning. All right. I missed anybody? Okay. All right.
That poor guy right there, man. He looked like, look, why am I here? I just want to be in a rap career. Lord, I'm over here. I just want to be on a rap.
Business the court needs to take up this morning. I have two motions to recuse. One filed by defendant Jeffrey Williams.
Who's that white lady?
That was filed yesterday.
Who's that white lady?
And handed to the court at the end of the business day. Another one has been filed under the same indictment, this indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers or the principal lawyer for that particular case to identify themselves for purpose of the record.
Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Jose, Mr. Morgan,
Oh my gosh.
Mr. Winchester.
All right, good morning, counsels. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to.
Where's ADA Love?
I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently another a copy of that, or?
We did not, Judge. I don't
Okay, no harm, no foul, no. So, no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else, and that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit, if are true, recusal would be warranted, and that is Dacker versus the state, 300 Georgia 74 at 77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was, in fact, filed on this past
Nobody cares. Come on.
Monday. which would have been the 17th of June.
Nobody cares.
I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed as it was filed on the.
I really don't think that's the biggest issue.
It's filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And
I'm just going to say this right now. I believe he knows it. He doesn't have he knows he doesn't have a leg to stand on because he keeps referring back to the screen, He's moved the coffee cup. He's moved the mouse. Now he's picking up his papers. I guarantee he's just going to stamp them and then put them back down. He's nervous. He's just going back and forth with movements to slow down what he wants to say. See?
The court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do.
Okay.
Not quite what I said. We've identified.
Ooh, what happened to Love's hair?
The problem, the mountain we're climbing is both sides have their own transcript, and the pages are not the same. So we're working off two different transcripts, and we have converted our files to MP3. They're still going off the evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work. It's just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time consuming process.
Okay.
We're working as quickly as we can.
If they have redactions that they have identified at this point and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript that they have, so that the downtime isn't a total wash, and we'll be able to make some kind of progress.
All right. Sure.
I will see.
Okay, I'm going to jump back to the recusal because it sounds like they're just doing redactions. Thumbs up if you drop a 1 in the chat if you want us to jump back and hear what he said about the recusal versus these redactions. drop a 1 in the chat or drop another.
Okay.
Drop any other number if you want to stay on this.
In their media format, however they give it to us, and we can know whether we agree or disagree with it in the format that they have it right now.
Okay. So how much longer will you all need?
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite.
That both contain assertions.
I understand the court's ruling and we'll.
That's where we are at this point in time.
All right. So
Anything else?
overall consensus. Let's jump back.
If I could just briefly be heard, Judge.
Sure.
Where's Steele? Oh, Steele's there. Okay. Man, it's a mess.
I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be. I mean, the appellate court will review my ruling for abuse of discretion.
Certainly understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. Okay. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertains or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also...
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
That would be crazy. Here comes Steel Jacket.
I have read Baptiste versus State. I've read all the cases that I believe are applicable, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland.
Right.
And assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any,
Very good.
the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling.
Wow.
Respectfully.
I also, on
said
the
you ain't mean nothing.
transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm
how.
not gonna, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver is gonna prepare the record. She does that, and like I said earlier, the record should be ready soon.
Yes, I agree.
And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
Not to interrupt the court, that finishes our business today, man. We be
You don't want to stick around? Okay. Well, okay. Thank you, Mr. Banks. Okay. All right.
He said, we in the win.
Yes, you may be excused, sir.
He said, we ain't going to be here. We're not going to be here. I'm with them. I don't want to be out of there. Yeah, little Woody is definitely, his life is definitely going to be turned upside down.
All right. Ms. Hilton and counsels, what matters you have to take up from the interview from the the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th probably around 11:30. We have not heard from defense counsel yet, so I'm not sure if they've reviewed them and if they have any additions or disagreement. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish for us to talk about? Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court. However, is favored, but I can't say at this moment that we've cross-referenced the two lists.
Can you imagine how long this is?
All right, so that's what we're supposed to do this morning, though. So, does anybody else have flagged or wish to be heard on the interview for January the 28th?
Where?
Sure. We're going to cover them independently. Like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't.
May have what? Sorry, I'm sorry.
Hold on, let me look, because now you got me interested.
For interviews
Stephen
from January.
Earhart. All right, let's see.
You don't want to stick around? Okay. Well, okay. Thank you, Mr. Banks. At all? Okay. All right. Okay. Yes, you may be excused, sir.
Okay, I think those are seat cushions. Those are seat cushions, I think. I don't think those are bags or computers. I think those are seat cushions. I've seen them before. I think they literally, you can get a seat cushion because you'll be sitting there on that hard bench for so long. I think that's what that is. Let me jump back to where we were, because this is not long. They're going to go to recess in a minute.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to just talk to the state about their list?
Yeah. And does anybody else have any statements that they've identified from the January 28th or February 21st?
Man, this is so terrible.
Other than Mr. Steele or Mr. Sharp that they want to bring up? All right. Okay. All right, then I'll give you all 15 minutes, and you can come
15
back.
minutes, going to be 20 minutes.
We can just begin with the 28th of January interviews, okay? All right.
Oh, you know what? That other white lady is probably the stand-in because that attorney had COVID, was exposed to COVID or whatever. Oh, it's all good. I would have thought it was a bag too, but I think that is I'm pretty sure those are seat cushions because there's a couple of them sitting there. And I could only imagine, man, oh my gosh. The jury, man, I probably need like a blanket, a little sleep mask. Oh my gosh. It would be terrible. I could only imagine how terrible that is. That's a cruel and no punishment. That's all I can say. That would just be cruel and unusual punishment for sure. All right, let me real quick check the traps. All right, I see me. All right, I think we are good to go. I think when they come back, they're going to still be talking about the redactions, which is just, oh gosh. And all because they did not have a good witness, because they pressured the witness into testifying when he didn't want to. So he's going to be a complete and total tool and just a burr in their saddle because he doesn't want to be there. Man, that's crazy. If they had just not hitched all their horse to Woody, we wouldn't be having this conversation. All right, let me see real quick. Why is Woody is on. All right, so I'm just looking. All right, I'm looking to see. Apparently, Woody was on Instagram. This is craziness. Woody is on live right now. This is craziness, y'all. He's in Atlantic Station, man. Yo, this is craziness. I'm over here looking at Woody on Instagram, but I think he left he had a live stream, but I don't think he's there. He's doing it anymore. Man, this dude gonna have you out here stuck like Chuck. I do not recall. Okay, real quick. So y'all can see what I'm looking at. All right, so I'm over here. This is Woody's Instagram. The dude, oh, man. I'm not saying you can't live your life and all that kind of stuff. But I mean, he was literally on live stream earlier. Man, if you don't get out of here with that foolishness. He out here. That's him. That's Woody. That's Woody right there. I ain't messing with people's cars. Leave people's cars alone. Get out there on the bird scooter on the Adidas slides. He got a whole bunch of money. Okay. All right. Got a bunch of money. Got a little. All right. All right. It's always a rule of thumb. How he flexing in front of the police. Y'all, please stop this guy. Please stop, Woody. All right. Y'all pray for him, man. Pray for him, man. All right. So he was, apparently he was on live stream. Like live streaming while he was. Yo, this is crazy. Man. This case is bananas. Okay. I'm going to follow him just in case he won't ever come and talk. He needs somebody to talk with him. I'll talk with him for sure. I'll talk with Woody. I'll probably even talk to him off camera. Let me see his reels. That's him and his kids. All right. I don't know where this live was that he was on, but apparently he was live. So that's craziness. I just think it's telling that your witness is doing all kinds of debauchery online. It's just, he does need to monetize for sure. Wasn't he supposed to be in court? No, they're doing the redactions today, so he didn't have to be there today or tomorrow. He needs to monetize it. He got that fanny cash. Fawny cash. I see what you did there. I see it. I wonder if he following. Let's see who's following him. He got his Fawny following him. That is hilarious, man. Yeah, this guy is he's a different kind of guy. Bless his heart. I feel sorry for him though. Yeah. All right, now that I got trapped going down the rabbit hole looking at his Instagram. It's kind of wild. Y'all pray for Woody. Pray for Woody. Pray for Woody. Woody needs Jesus, man. Please, Lord. Save Woody. Save him. All right, so we got that done. I appreciate y'all. Let's see if all right, so the Young Thug case, what is that? Okay, so they're redacting information today. That's going to be super boring because they're not even watching it. They're just like arguing about whether or not they should watch it and so forth. So that's just, all right. So thank you so much again, Transplanted Texan. There's Brian Steele's motion to recuse. I still think it was great, but I mean, clearly Judge Glanville did not. But I kind of expected it, but I don't know, is there a way to go to someone above the Chief Superior Court Justice because you feel like he's doing the wrong things, but that is what it is. Let's see what we got. Yeah, this is super wild. Let's see real quick. Checking the traps if anybody else is talking about this or anything new has popped up. Yeah, like he was in the, like, I want to know where this went, but he was in the grocery store. Lead and AV, like he was like literally in the grocery store. Like what happened to this? This looks like it was yesterday. Oh, this was a hoodie he had on yesterday, so maybe that's like his favorite hoodie, like mine. Okay, so they were trying to spam him and get him to come on lead attorney. Detective Woody. They are so foul in there. Woody. They are so foul in the chat, in his comments. Woody, join lead attorney right there. Bro, join the lead attorney. Come on to the lead attorney. They are giving him the business. They are really trying to get him on there. That would have been wild. They are trying, though. They're trying. That is wild. Woody, come on, dear woke Christian. What about that? You need to write a book ASAP. That's hilarious. I wonder what happened to this. Why was this gone? It's Woody versus Woody. That's the one I was on. Keeping up. What does that say? Keeping up with something right there. I don't know what that says. I have no idea what they're talking about, so I've muted it because I don't know if there's any music that pops up or anything like that. Stand on 10, Woody. Why they put pressure on you like that? Join the lead attorney live. Superstar snitch. I don't recall. The lead attorney. They should have dropped the link though. That's the problem. Like they didn't put the link on there. I think that would have made it a little bit easier. Join the lead attorney on YouTube channel. That is hilarious if he had gotten on there. Oh, this is interesting. Stephen says, I'm sure someone in the DA's office is going to report his live stream to the court. The defense is aware and hope they stay quiet. Allow him to say what he's going to do. Yeah, there you go. Yeah, that would imagine if he had gone on live or if people were asking him like, hey, what did they say in that ex parte meeting? And he implicated and said, yeah, they threatened me. They put pressure on me. Oh my gosh. This could be crazy. Say what, lead attorney? Join the lead attorney. Oh, the stream ended. That's why. That is craziness. Yo, if he had gone on, it'd been wild. Oh my gosh. I have no idea what to say about that one. If he had come on. But it doesn't like he was saying anything. It just seemed like they were just spamming him to get him to come on. But what in the world? Okay, there we go. It looked like they were just spamming him, but nobody was it doesn't look like he was saying anything, but maybe he was. But that was wild. Oh, Woody, good old Woody. Let's do this, y'all. Let's do this. Because we know the rest of the court today is just going to be them, and they're currently still in session. So we know the rest of today is going to be just them recusing information and whatnot. So let's probably jump back in. So I went over both the motions, Ashley's as well as Brian Steele's. We heard Judge Glanville say he ain't going nowhere. I ain't going nowhere, y'all. Y'all gonna have to do more than that. Filing some motions to get me up out of here. I'm here to get this smoke. That's what Judge Glanville said. At least that's what I'd say he said. But no, I appreciate it, Joe. Rumor has it, I heard about this Sylvia lady because she's in the courtroom from another channel, spoke with Bumpkins' lawyer, and he says Bumpkins was not the mole. Okay, well, Brian seemed to have said that, but maybe they're wrong. It's possible. Man, it's yeah, I feel like, I mean, maybe it wasn't, but it feels like it was, like she was. Dude, she had 4 attorneys in there for that. 4. That's crazy. That is bananas, man. 4 attorneys or legal people, whatever. And that's just one attorney. So imagine, man, like I said, man, this is bananas. I don't even know where to go with this case. But let's do this, everybody. Let's do this. I am going to look at the time. It is 12:15. Almost 1. Yes, please, if you're not getting notifications, because if I go live again this evening to recap, or hopefully I have a guest, whatever like that, if you don't get notifications, and this is for any of your favorite YouTube content creators or even other socials, just follow this link. It's a short that explains how to make sure you get notifications. And I think it's been helpful. Lots of people now reporting that they're getting notifications and they weren't getting it before. So it might be something worth checking out if you're not getting notifications. I want to thank you all so much for starting the morning off with me. I appreciate you. Hopefully you're having a great work week and great things are going on in your side of town. Let's do this again real soon. I'm looking forward. I'll probably come back tonight and talk again because I'd love to connect with you all and see where you all are. But it seems like most people are kind of enthralled in this story right now. And I want to come back when there's actually something new to talk about. So let's do that real quick. Okay. in my opinion, if Kayla Bumpus told anybody, Kayla Bumpus is the mole. I don't like using the word mole. She's the hero, if you will. So if she told anybody that she's the one she's the hero, the mole, the person that give the informant. There you go. So that would be my pushback on that, but it really doesn't matter. I think that the story shouldn't have happened. That's the part that really gets past us. The story shouldn't have happened. So let's do this again. I'll be checking the traps throughout the day. I'm gonna go look, check up on Chief Executive Second Born, and then I gotta do some things for the family. But let's do this again real soon. I'll put up a thumbnail as soon as I decide what time we're going live tonight. Everybody, I want to thank you so much for support. Thank you so much for tuning in. I appreciate you hitting that like button if you have not already done so. Make sure you check out the other videos that are on the channel and let me know what you think about it. And God willing, real soon, we'll do it again. Grace and peace, everybody. Take care.